Good evening, all of you. Let's start. Good evening to all my friends online and offline also. Uh, so we will first revisit what we have done on that day, then we'll be starting. Okay. So, okay. So we have the reorganization of states in India. So post-independence, there was constant demand to create states on the basis of language being a very sensitive aspect of culture. So undoubtedly, this what you call the Parliament of India. So at that time, the government was not in a mood. Why? Because they thought ki we will allow some years to pass. Then national integration perspective, a nation has just formed. So it is like in the sense ki after independence, it will take time actually. So that the idea of India gets more strengthened and then we'll create on the basis of language. But finally, there was Dhar Commission, that was Linguistic Commission, which rejected the idea. Then Indian National Congress, actually the party, which constituted a committee, okay, which also rejected the idea. Then there was a demand on by Potti Sri Ramulu, who died on a hunger strike on 56th day. Okay, so there was a this led to widespread resentment and creation of Andhra Pradesh. And of course, if you create one state, there are similar demands that are going to come. And this government constituted Fazle Ali Commission, and Hirdanath Kunjru and K.M. Panekkar were two other people. They by and large, they rejected this question. Actually, has been asked that if I make this statement that State Reorganization Commission rejected one language, one state formula. Is it a correct statement or a false statement? Yes. But broadly accepted that language can be a basis without compromising on national security, economic and administrative factors. Then the parliament went ahead and two separate bills were introduced. One on ordinary law, that is State Reorganization Act, and the other was a Constitution Amendment Bill, which also created the office of Special Officer for Linguistic Minorities. Okay, so after this we ventured into part 3 of the Constitution, that is fundamental rights. So part 3, fundamental rights. Why they are called fundamental rights? Because they are fundamental for human existence. And what is the prime purpose of these rights? Rather than being positive, they establish a liberal democratic state. Okay, why? Because they restrict the power of government and ensures that the government is a constitutional limitations are there. So it promotes the idea of constitutionalism, okay, and the idea of constitutionalism where the government is a limited one and the real power vests with the people. So most of the fundamental rights are negative in nature, but many of them also have positive aspects. Okay, so if you see fundamental rights, there are other rights also. They are emanating from a piece of legislation, so they are statutory rights. Some rights which are outside part 3 but in the constitution, so they are constitutional rights. One such question, a very controversial one, was asked 3 years back, that was right to vote, and the UPSC settled the debate that right to vote is a constitutional right under Article 326 of the Constitution, and it is not a fundamental right. Although the Supreme Court at times has emphasized, especially in Association for Democratic Reforms case, that right to vote also forms part of expression. Okay, that is Article 19(1)(a). Implicitly, it is also a part of Article 19(1)(a). But since explicitly it is provided in Article 326, so that was the element that was taken, and finally the answer key came. Okay, one or two questions, undoubtedly there will be controversial questions every year. This year they cancelled 2 questions. One question because of translation. In Hindi, it was written Asayog Andolan, that is non-cooperation movement. In English, it was written civil disobedience movement. So that question was cancelled, and there was a science and technology question on or some pressure cooker something that was also cancelled. Okay. Otherwise, there for last 5-6 years, there won't be a single answer key in the country. You can go and search on internet where all the 100 questions would be correct. One or two question is always debatable because there is an element of subjectivity. ठीक है, कोई problem नहीं है. Cutoff is less than 50%. So there is no need to worry about that. There would be an element of subjectivity. Otherwise, you will few questions. I don't know why they keep it a point. They keep it a bit subjective. Okay. So by and large, what kind of questions they are asking? Concept based. So fundamental rights में they are restrictions on the power of state. They promote a limited government. They are fundamental for human existence. the remedy. A right without remedy is of no use. A right without remedy, if your right is violated, remedy must be secured. So a right without remedy is of no use. What is a general accepted definition of right? Rights are legally protected interests. So there must be a legal protection. So you have part 3 of the Constitution, which is fundamental rights. And of course, without a shadow of doubt, they are secured with highest sanctity. Article 32. We will see later. Enforcement of fundamental right is also a fundamental right. India is among the few countries on earth where enforcement of fundamental right is also a fundamental right. To enforce a fundamental right under Article 32 itself has been made a fundamental right. And Dr. Ambedkar made this beautiful statement that Article 32 is heart and the very soul of the Constitution. And part 3 is Magna Carta of the Constitution. That is the most important part. So once most of these fundamental rights are applicable against state. If fundamental rights are violated by the state, either by an executive order or by a legislative provision or by a constitutional amendment, these are the ways in which it can be violated by the state, either by an executive order or by a constitutional amendment or by an ordinary law or by a delegated legislation. Okay, we'll see them. So you have to define state for the sake of fundamental rights. If we do not define state for the sake of fundamental right, from whom against whom we will make these fundamental rights applicable? If I tell you that go and collect the material from the authority, so I should be very specific. There are so many people in the organization who are authoritative position, finance department or any other position. So I must specifically tell you from what desk number 48 or this particular individual shall be handing over the material. So if fundamental rights are applicable against the state, we have to define state. If we do not define state, against whom these fundamental rights are applicable? So Article 12 attempts to do that. So what is the first definition of state? That is union government and union parliament, no problem. Second, state government and state legislature, again no problem. Local authorities, you have Panchayati Raj institutions and urban local bodies, no problem. And finally, the etc., other, these are dangerous terms. In syllabus, they have mentioned etc. You imagine the magnitude of that small etc. Okay, they can ask anything. They write current issues of national and international importance. So they can ask the Prime Minister of Lesotho. So we have to find out a bracket within which you have to see. There are 3 levels of doing anything. First level, you are introduced to that idea. Second level, you get a grasp of that idea. If you consistently do that, there would be a level very soon you will conquer the syllabus. Consistently, you have to give 1 year. Then you will be so comfortable कि they will be discussing 96 आ रहा है and you will be like 124 आ रहा है, क्या करें? So getting my point na? So you have to reach that level. For that level, it has to be consistently hard work. Okay. And toughest thing in the world is consistency. Gym, giving up eating. Okay. Anything, ek din to, it is extremely passionate. But to continue that is a brutal exercise on your body and mind. Okay. So that is a very tough thing. Very tough thing. To be consistent on a particular thing. So that exactly, it is pure about mental agility. Pure, pura exam mental test. Endurance of mental agility. How long you can sustain that spirit inside you. That is the average students making it. Average, very, very average students, very average students, not always IITians, because of the mental agility. So that must be the spirit. Okay. So Article 12, other authorities had been tried to explain by Supreme Court in various judgments. Supreme Court judgments are divided into 2 parts. For example, there is a 400-page judgment. So 350 pages would be quotes, Shakespeare, Eliot, Jane Austen. So they will write all these things and they would be like, it is called obiter dicta. That part of the judgment which is not binding. Which is why they are reaching a conclusion, that part of the judgment which gives a reasoned detail why we are arriving at this conclusion. And that part of the judgment that is binding is called ratio decidendi. So that is that part of the judgment which is binding, which is a brief part. Many times they do not distinguish. To explain one judgment, you have 5 more judgments. So Article 141 of the Constitution says that every judgment of Supreme Court shall have validity of law and shall be binding on all courts in India. So the judgment of Supreme Court is a public property. I'll give you an example and you will understand. For example, you were accused in a case, okay? And then I'll come to how the Supreme Court definition is applicable to Article 12. You were accused in a case and you filed for bail in Supreme Court, okay? And then you were granted bail. Now, whenever somebody searches your name on Google, the first case that comes is that case where you were accused of a heinous offense. Now you have moved on. Now you want that particular case to be removed from the Google search. Why? Because it brings loss of reputation to you. You cannot do that. Because the judgment of Supreme Court acts as a court of record and every judgment is binding on all court. It is a public property. You cannot do that. It will be open in public discourse. So any judgment given by Supreme Court has a binding value and all courts in India has to adhere. For example, there is a provision in CRPC. And there are 7 different interpretations by 7 different high courts. Then one of the high court will refer the matter to the Supreme Court. Because once the Supreme Court decides, it is binding on all courts in India. So Supreme Court has given few parameters where to determine whether an agency is working as an instrument of state or substantial financing or appointments or a government department is converted into corporation, then they will also qualify as state. Then the last thing that we discussed was Article 13. Okay. Article 13 is classified into 2 parts. Did we discuss pre-constitutional and post-constitutional laws? Okay? Okay. Would you like to keep the energy saving in countdown? Keep it on, you're not in session. Keep it on. Okay? So we have kept it on. Okay, so we have Article 13 of the Constitution which we started. Exactly. Article 13 of the Constitution which we started. What is Article 13? Article 13 says, it is first, we discussed the Keshwananda Bharati judgment. Okay. So Keshwananda Bharati judgment is one of the most important judgments of Supreme Court. It is undoubtedly the most talked about judgment of Supreme Court. Why? Because of multiple things that came out and the judgment of Supreme Court has binding value as that of law. Okay. Can the Supreme Court, this question also has been asked, can the Supreme Court revisit its own judgment? So Supreme Court as a court of record can revisit its own judgment. What is the position of a judgment given by High Court with respect to other High Court? A judgment given by High Court is persuasive value for other High Court and binding value for all courts within it. So the judgment given by a court in Uttar Pradesh, High Court, shall be having binding value for all the subordinate courts in UP, but shall have persuasive value for the High Court of Patna or Chennai. So whenever there is a thing that is decided by Supreme Court, many times I read so many judgments where Supreme Court quotes the judgment of High Court. If a beautiful judgment has been given by High Court, Supreme Court also quotes that and acknowledges. Okay. So the next thing is Article 13 mein we discuss the term law. Okay. So the term law in Article 13, first and foremost question, does it include constitutional amendment or not? आराम से सोचिए, if this question has been asked in innumerable exams, that the term law in Article 13, does that include constitutional amendment or not? Huh? Okay, so it says that okay, so they are also answering. Online students. Okay, we'll come Rajiv, don't worry. Abhi sab hoga, sab ilaj hoga. Okay, Article 13 of the Constitution says that no law can abridge your fundamental right. Abridge matlab? Take away or take away. Okay? No law can abridge or take away your fundamental rights. So the term law in Article 13, ye I want all of you to understand. This is very important. If it means ordinary law, कोई भी law, I'll repeat in Hindi then in English, कोई भी law आपकी fundamental rights को नहीं ले सकता है. No law can take away your fundamental right. So if the term law means ordinary law, then only ordinary law cannot take away your fundamental right. If the term law means ordinary law as well as constitution amendment, then both ordinary law and constitution amendment cannot take away your fundamental right. So in Golaknath versus State of Punjab 1967 judgment, Supreme Court says that the term law in Article 13 means only constitution amendment or both. Ordinary laws and ordinary laws तो किसी सूरत में नहीं ले सकते हैं. It is not even a matter of debate. Ordinary laws cannot take away your fundamental right. It is not even a matter of debate. But whether constitution amendment can take away your fundamental right or not, it was a matter that was discussed in Golaknath versus State of Punjab. And Supreme Court gave a wide interpretation to the term law in Golaknath and said the term law in Article 13 includes both constitution amendment also and ordinary laws also. So does this restricted the power of parliament or expanded the power of parliament? Restricted the power of parliament कि parliament आपकी fundamental right ना ordinary law के through ले सकती है ना constitutional amendment के through ले सकती है, दोनों. So the restricted definition of term law would expand the power of legislature. The wide definition of term law would restrict the power of legislature. So this put a full stop on the power of parliament to amend the constitution. Part 3, they can amend part 3 but add a fundamental right. Because constitution says no law can take away your fundamental right. It doesn't say that no law can add. So it can add a new fundamental right but it cannot take away your fundamental rights. So the Supreme Court again in Keshwananda Bharti versus State of Kerala 24th April 1973 ruled that the term law in Article 13 only includes ordinary laws and it does not include constitutional amendment. Okay, so it does not include constitutional amendment. Thank you. So you are getting my point. It does not include constitutional amendment. So but subject to basic structure of the constitution. यानी parliament has unlimited power. केशवानंदा भारती से पहले गोलकनाथ केस में Supreme Court said parliament can amend the entire constitution but not part 3, that is fundamental right. It can amend to add a new right but it cannot amend to take a new right. Supreme Court in Keshwananda Bharti says no. Parliament can amend entire constitution including that of fundamental rights. Only restriction is it will not violate the basic structure of the constitution. Although there is a great debate over basic structure. I don't want to go into that. Isme kuch bhi UPSC would not be asking in GS. They just want you to know. So basic structure is a doctrine. Is a doctrine that has been given by Supreme Court in Keshwananda Bharti versus State of Kerala. And what is basic structure? This is our constitution. Okay. This is the edifice of the constitution, building of the constitution, which is resting on certain basic pillars. If you secularism, supremacy of constitution, separation of powers, federalism, rule of law, if you remove these basic pillars, the entire building of the constitution, edifice of the constitution shall fall. And the Supreme Court gives a reasoning in one of its paragraphs that there is a difference between constituent power of parliament to amend the constitution. The power of parliament to amend the constitution is coming from constitution itself. So power to amend the constitution is coming from constitution itself. So it cannot overcome the boundary of constitution. But the constituent assembly got the power from the people. So it could have made any constitution. So the Supreme Court clearly demarcates the difference between constituent power of constituent assembly and constituent power of parliament. And it says the constituent power of constituent assembly is unlimited, but the constituent power of parliament is limited. It can amend the entire constitution, we don't have a problem. You also amend preamble, which is a part of the constitution. You also amend fundamental right. We don't have a problem. Only thing that you keep in mind is without violating the basic structure of the constitution. And now the Supreme Court further says, in Raj Narayan case explained further how judicial review, and Minerva Mills case explicitly said that judicial review is the basic structure of the constitution. Again in IR Coelho case, Supreme Court 2007 में कहता है, the judgment of Keshavananda Bharati shall be prospectively applied. So what do you mean by prospectively applied? Yani, it will be applied from 24th April 1973, not from retrospectively, पीछे से. It will not be applied retrospectively, it will apply prospectively, and all laws that have been put under 9th schedule on or after 24th April 1973 shall be open for judicial review. Yani judicial review is the basic structure of the constitution. Basic structure has come from Keshavananda Bharati judgment. So those laws which are before 24th April, they are immune from judicial review. Those laws that are after 24th April, if they are inserted inside 9th schedule, they are open for judicial review. So basic structure doctrine was given by whom? First, by the Supreme Court of India. In which case? Keshavananda Bharati versus State of Kerala. On which date? 24th April 1973. What it says? That the Constitution of India is resting on certain basic pillars. You can amend the entire constitution but not amend the basic structure. What is basic structure? An organic document. Initially it was independence of judiciary, supremacy of constitution, now federalism, separation of powers, rule of law, democratic character of Indian state, republican character of Indian state. All these things have been held to be basic structure of the constitution. Whether the Supreme Court reversed the judgment of Golaknath? Yes. Golaknath absolutely restricted the power to amend fundamental rights. It cannot take away fundamental, and now it can. Okay. So I think we just discussed this. We were about to write. So please write Keshavananda Bharati versus State of Kerala. Okay. We'll deal. अभी लिखो. अच्छा हम लोग ठीक है. Okay. So please write Keshavananda Bharati versus State of Kerala. The Supreme Court in this landmark verdict, the Supreme Court in this landmark verdict ruled that, the Supreme Court in this landmark verdict ruled that the Constitution of India, the Constitution of India is the Constitution of India is resting on certain basic, the Constitution of India is resting on certain basic pillars, known as basic structure. Known as basic structure, and the constituent power of parliament to amend the constitution constituent power of parliament to amend the constitution does not include constituent power of parliament to amend the constitution does not include the power to alter the basic structure. Does not include the power to alter the basic structure. Thus, the power to amend the constitution is limited by is limited by basic structure doctrine. Is limited by basic structure doctrine. Full stop. Next point लिखे. अब point wise. ये तो एक just a synopsis. Just like case name, put a dash and semicolon. Case name. Keshwananda Bharti versus State of Kerala. Case name. Keshwananda Bharti versus State of Kerala. Then you write Keshwananda Bharti versus State of Kerala, then delivered on. Actually, UPSC will never ask this question. But I know somebody who went for UPPSC interview. Exactly, they asked this question. That when was Keshwananda Bharti case delivered? Okay. So, delivered on 24th April 1973. Delivered on 24th April 1973. Okay, then delivered on 24th April 1973. अब ये भी लिख ही लीजिए 7-6 judgment. 7-6 मतलब 7 people supported a majority judgment and 6 people actually negated the idea. But who will prevail? 7 people. तो bracket में you can write 7-6 judgment. उस वक्त की highest bench थी 7-6 judgment. यानी 7 people supported the judgment and 6 judges opposed it. So who will? Sabrimala judgment. 5 judge bench sits. 4 judges, there were 4 male judges, 1 female judge, Honorable Justice Indu Malhotra ma'am. She said ki nahi, women should not be allowed to enter Sabrimala temple complex. 4 male judges said ki yes, women should be allowed to enter Sabrimala temple complex. So whose judgment prevailed? 4 majority and 1, she gave a minority judgment. Okay, so you are getting my point. Many a times a minority judgment tomorrow becomes a majority judgment. So tomorrow court acknowledges actually अब छोड़िए हटाई तो लिखिए क्या लिखा आपने अब फिर कहानी चलेगी फिर कुछ कुछ आ जाएगा हाँ 7-6 judgment okay so 7 judges supported the basic structure doctrine 6 judges were of the view that parliament has unlimited power. Next you write the basic structure doctrine has neither been mentioned. The basic structure doctrine has neither been mentioned basic structure doctrine has neither been mentioned nor basic structure doctrine has neither been mentioned nor defined in the constitution. Again this is a prelims question. Has neither been mentioned nor defined in the constitution. Full stop. Next you write, thus the Supreme Court overturned the Golaknath verdict, bracket mein 1967. Thus the Supreme Court overturned the Golaknath verdict. Thus the Supreme Court overturned the Golaknath, Golaknath, Golaknath verdict, bracket mein 1967, wherein they interpreted the term law, in Article 13, wherein they interpreted the term law in Article 13 to include constitutional amendments also, full stop. To include constitutional amendments also. Full stop. Then you write next line, in K. Bharti case, the apex court ruled that the term law in Article 13 does not include constitutional amendments. Does not include constitutional amendments. Okay, full stop. ठीक है, next point you write. Basic structure does not include constitutional amendments, full stop. Next point you write. Basic structure doctrine is an organic one. Basic structure doctrine is an organic one. Is an organic one. And basic structure doctrine is an organic one, and it has been expanded by basic structure doctrine is an organic one, and it has been expanded by whom? By the Supreme Court time to time. A, अब लिखिए मतलब क्या क्या है, what all things are part of basic structure. A, what should be the first basic structure? हाँ हाँ, सबसे पहले यह मानना है कॉन्स्टिट्यूशन इज सुप्रीम. Everything will come second. Federalism, rule of law, republican character, separation of powers, secularism, democratic character of Indian state, judicial review, independence of judiciary, everything will come second. पहले ये मानिए कि पार्लियामेंट सुप्रीम नहीं है, जुडिशरी सुप्रीम नहीं है, लेजिस्लेचर ये एग्जीक्यूटिव सुप्रीम नहीं है, हु इज सुप्रीम? So first basic structure shall always be the supremacy of the constitution. Please write. Huh? Organic matlab keeps growing. Supreme Court can add something later. Okay? So first is supremacy of the constitution. Second, independence of judiciary. Third, rule of law. Supremacy of the constitution, independence of judiciary, rule of law. Next, secularism. Secularism. Next, federal character of Indian state. Federal character of Indian state. Etc. ठीक है? So this keeps growing. Okay, now write a concluding paragraph on Keshwananda Bharti. Please write. This judgment had wide ramifications. This judgment had wide ramifications. Ramification matlab effects. Okay. Wide ramifications in promoting the spirit of constitutionalism. This judgment has wide ramification in promoting the spirit of constitutionalism and separation of powers. It seeks to maintain a democratic order by securing basic tenets of Indian constitution. By securing basic tenets of TENET, by securing basic tenets of Indian constitution, which cannot be altered, basic tenets of Indian constitution which cannot be altered under any circumstances, Just a second, I want you to see article we have opened. Article 13. See, for UPSC, they will, for GS paper, okay, GS paper, they will not be asking much concept. Although Article 12 पे recently एक किताब आई है. Faizan Mustafa, sir, he has also talked about that book. So it is not required. You just need to, even 12 is, most of the time it is not taught also. We'll see just one important thing, that is, Rautwari, this 31 aa gaya. Okay, so you just see Article 13 of the Constitution, you will understand. So let us have a look over this. Okay, so we have Article 12. It says in this part, so we have already seen the definition of state. Okay, it says government and parliament of India, government and legislature of each state, all local and other authorities. Okay, next you have Article 13. Although Article 13 from conceptual point of view is a beautiful article, it is a heaven. For example, certain provisions in CRPC is a heaven for lawyers. For a constitutional law expert, Article 13 is a heaven. इतना खूबसूरत आर्टिकल है, so many interpretations have come, we can discuss for 5 days. Okay, but what is important, UPSC perspective, GS, you must understand, all laws in force in the territory of India immediately before the commencement of constitution, all laws in force in the territory of India before the commencement of constitution. So you have Indian Penal Code 1860, Land Acquisition Act 1894, Industrial Dispute Act 1947, है ना भाई, constitution जब आया उससे पहले से, all laws in force before the territory of, in the territory of India before the commencement of constitution, insofar as they are inconsistent with the provisions of this part. So if they are inconsistent, matlab they are not in harmony with the fundamental rights, that is part 3, shall to the extent of such inconsistency be void. यानी जितना हद तक वो इनकंसिस्टेंट है उस हद तक उनको void घोषित किया जाएगा. यानी पूरे लॉ को घोषित नहीं किया जाएगा अनकॉन्स्टिट्यूशनल, सिर्फ उन पार्ट्स को. आई एम रिपीटिंग इन इंग्लिश, ओनली इफ देयर आर 198 सेक्शंस इन अ लॉ, then only those sections would be declared as unconstitutional and void which are inconsistent with part 3. So this is not talking about declaring the entire law as unconstitutional, but only that part of the law which is inconsistent. So all those laws that came before the constitution. So before the constitution we have hundreds of ordinary laws. After the constitution we have hundreds of ordinary laws. Constitution is only one. Every session of parliament there would be 1 or 2 or 5 or 7 ordinary laws passed. It says all laws in force before the territory of India immediately before the commencement of constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. Yani entire law will not be declared as void, only that part. Now next point. अब कह रहा है ये तो हो गया प्री कॉन्स्टिट्यूशन, पर पोस्ट कॉन्स्टिट्यूशन भी तो सूरज होगा. After 26 January also you have sun rises every day. Okay, so you getting, पहली किरण कहां पड़ती है सूरज की? जापान. इंडिया में कहां पड़ती? So in Arunachal at 3:40 there would be, 4 o'clock there would be sunrise, while in Ahmedabad, Gujarat it would be, they are demanding a different time zone also, a Chai Bagan time zone. But in India literacy, no, this is a very commonsensical, that if sun sets by 4 or 4:40 or 5, okay, during winters, so the office timings cannot be uniform, na? So it is like, it is a, anyways. So you have, ab aa raha hai, the state shall not make any law, yani shall not make any law, yani ab aage koi law, yani ki this is talking about pre-constitutional laws or post-constitutional law. Post-constitutional. The state shall not make any law which takes away, जो आपकी fundamental right को छीन लेता है, और abridges the right. छीनता भी नहीं है, आप में और फंडामेंटल राइट में दूरी पैदा कर देता है. इट डजंट टेक अवे योर फंडामेंटल राइट, मेक्स इट डिफिकल्ट फॉर यू टू एक्सेस फंडामेंटल राइट्स. It's not that they will take away your fundamental right, they will make it difficult for you to access fundamental rights also, na? So abridges fundamental right. You are here, that some person is there is a bridge which connects us. Okay, so there is a, if you remove the bridge we are actually abridged. Okay, so abridging, if there is a distance between you and fundamental rights. So you have, the state shall not make any law which takes away or abridges the rights conferred by this part. And any law made in contravention of this clause, matlab any law that violates this clause, shall to the extent of contravention be void. Yani पूरे लॉ को अनकॉन्स्टिट्यूशनल घोषित नहीं करेंगे. वी विल नॉट डिक्लेयर द होल लॉ एज अनकॉन्स्टिट्यूशनल, ओनली दैट पार्ट विच कॉन्ट्रीब्यूट. क्लासिक एग्जांपल, द पार्लियामेंट ऑफ इंडिया, समझ में आ रहा है ना आप लोगों को, इनैक्टेड इंफॉर्मेशन टेक्नोलॉजी एक्ट 2000. इंफॉर्मेशन टेक्नोलॉजी एक्ट 2000 पास किया पार्लियामेंट. देयर आर मेनी सेक्शंस इन द एक्ट. वन ऑफ दोस सेक्शंस वायलेटिंग आर्टिकल 191A. Section 66A is violating Article 191A. It was declared as unconstitutional in Shreya Singhal versus Union of India case. So क्या कह रहा है? Entire constitution will not be declared unconstitutional. Entire law will not be declared unconstitutional. Only that part of the law which actually contravenes. So दोनों पार्ट में, प्री कॉन्स्टिट्यूशनल लॉज में भी और पोस्ट कॉन्स्टिट्यूशनल लॉज में भी, दे कैन नॉट टेक अवे योर फंडामेंटल राइट. इफ दे अटेम्प्ट टू टेक अवे फंडामेंटल राइट, they actually will be declared void only to the level of inconsistency or contravention. Yani entire law will be saved. Okay. Second thing is, the term judicial review is not mentioned in the constitution. Kahin bhi nahi judicial review. The term, हाँ कोई बात, we'll see federalism. अभी क्यों ले रहे हैं फेडरल, अभी फिर शुरू होगा, 2-4 दिन चलेगा, आराम से रहिए, क्यों दिल पे ले रहे हैं. सुनिए, फेडरल वर्ड नहीं यूज हुआ है. फेडरलिज्म इज लाइक ऑनेस्टी, डिसिप्लिन, इनसिक्योरिटी. कैन यू टच दैट? यू कैन टच अ डोंकी बट यू कैन नॉट टच फेडरल, बिकॉज एक्चुअली फेडरलिज्म इज अ फीचर. ओके, फेडरलिज्म एक टैंजिबल चीज नहीं है. इट इज एन, ऑनेस्टी का क्या कलर होता है? No color, but it is a feature. First of all, federalism has not been defined in the constitution. Second, the term federal has not been used in the constitution. Third, the idea of federalism has come from United States of America. Fourth, even if the term has not been mentioned in the constitution, on 11th March 1994, Supreme Court in S.R. Bomai case ruled that federalism is the basic structure of the constitution. And the most important thing, there is no agreed definition of federalism. Certain features, if they are found, country is said to be federal. Indian constitution has federal features: written constitution, independent judiciary, dual polity, division of powers. It also has unitary features: single citizenship, all India services, office of CAG, appointment of governor by the center, single constitution, multiple issues. So there are federal features also and unitary features also. Nobody can dare to say that it is completely federal or completely unitary. Different scholars see the constitution through different prism. Ivor Jennings, Casey Weir, somebody says that it is federal with unitary bias. कोई कहता है it is quasi-federal. कोई कहता है it is cooperative federal. कोई कहता है, Paul Appleby says that it is very strongly federal. So every scholar sees through their own prism. Supreme Court says federalism is the basic structure. So वो कुछ फीचर्स हैं जिससे पता चल रहा है फेडरल है, लेकिन कुछ ऐसे भी फीचर्स हैं जिससे पता चलता है फेडरल नहीं है. इसीलिए फेडरलिज्म पे अभी हम डिबेट करेंगे. व्हेन वील बी डूइंग फेडरलिज्म, वील डू लेजिस्लेटिव, एग्जीक्यूटिव, फाइनेंशियल रिलेशंस, इंटरस्टेट वाटर डिस्प्यूट एंड एवरीथिंग. ओके, लेट्स कम टू हियर. सो नाउ द बेस, वी वर टॉकिंग अबाउट प्री कॉन्स्टिट्यूशनल लॉज एंड पोस्ट कॉन्स्टिट्यूशनल लॉज. दे कैन नॉट बी void, they can be declared void to the level of inconsistency. Now why, and you actually you are asking a question because you have just started, you just heard about federalism, पूछ दिया. अभी विल डिस्कस दीज थिंग्स. व्हाई दिस इज मेंशन्ड? क्योंकि एक रीजन है. आर्टिकल 366 ऑफ द कॉन्स्टिट्यूशन अटेम्प्ट्स टू डिफाइन एवरीथिंग, एंड इन दैट डेफिनेशन अनटचेबिलिटी इज नॉट डिफाइंड. Federalism is not defined. Secularism is not defined. Minority is not defined. That is why they ask question time and again in prelims that the term secular has not been defined, term minority has not been defined, term untouchability has not been defined, term federal has not been defined, term judicial review has not been defined, term basic structure has not been mentioned. क्योंकि आर्टिकल 366 में सारे definitions हैं, वहां सेक्युलरिज्म, फेडरलिज्म और इनका डेफिनेशंस नहीं है. व्हेन द यूपीएससी आस्क अ क्वेश्चन, द टर्म सेक्युलरिज्म हैज नॉट बीन डिफाइंड इन द कॉन्स्टिट्यूशन, वो कोई आपसे मजाक नहीं कर रहा है. इट वांट्स यू टू नो दैट देयर इज एन आर्टिकल व्हिच हैज ऑल द डेफिनेशंस वेयर द टर्म सेक्युलरिज्म इज not mentioned. Now let's come to this. So the term judicial review is not mentioned in the constitution, but even a naive can say that this is exactly highlighting जुडिशियल रिव्यू. कौन अनकॉन्स्टिट्यूशनल घोषित करेगा? हु विल डिक्लेयर दिस एज अनकॉन्स्टिट्यूशनल? जुडिशरी डिक्लेयर करेगा ना अनकॉन्स्टिट्यूशनल. सो द टर्म जुडिशियल रिव्यू इज नोवेयर मेंशन्ड इन द, इवन इन यूएस कॉन्स्टिट्यूशन. Our constitution, we were adding due process of law. Then the advisor to Constituent Assembly, B.N. Rao, went to USA And then he had a discussion with the judge of US Supreme Court who advised that go for procedure established by law. That's a long story. But the point is that judicial review is not mentioned in the constitution, but it is being highlighted. ये क्या है? Judicial review नहीं है तो क्या है? Who will declare that law as unconstitutional? अब आता है second part, which question, although इतना deep they cannot ask, but still, law. So if the term law has a narrow definition, will it be good for democracy or bad for democracy? Leave the constitutional amendment debate aside. अब एक बहुत ही conceptual question पूछता हूं. Leave that debate of constitutional amendment aside. कि whether the term constitutional amendment the term law includes constitution amendment or not, ये Supreme Court has settled. That the term law in Article 13 does not include constitutional amendment. Leave that debate aside. Leaving that debate aside, the term law in Article 13 should be wide. If it is wide, it is good for democracy, or it is not narrow, it is good for democracy. Wide, इसीलिए कहीं ऐसे ना कर सके तो ऐसे कर दे. What you cannot do directly, you try to do indirectly. To avoid such a situation, Parliament has expanded the definition of law. Law includes ordinances. We'll see Article 123 of the Constitution. Bylaws, laws made by local authority. Regulations, any official order that tries to regulate a particular process, mechanism, or administrative process. Notification, to inform through a government sanctity. Custom, koi parampara, sabhyata, sanskriti. It says na, Babuji parampara. Okay, so it is usage, matlab something that is in practice in the territory of India. So the term law has a wide connotation. Why this was, a Supreme Court also acknowledges that if they would have meant to include constitutional amendment in Article 13, they would have sub mention किया. पैसा लग रहा था, यहाँ पे constitution amendment भी जोड़ देता. अगर constituent assembly को, if the founding mothers and fathers of constitution had this intention to include constitution amendment also, they would have added here कि the term law in Article 13 includes. So they did not add over here, which reflects the minds of the makers of the country. Okay, this question has been asked in 2017. Which part of the constitution reflects the minds of the makers of the constitution? It is preamble. ये question आया. अब देखिए, the term law includes ordinances, अध्यादेश issued under Article 123. कोई भी ऐसा local authority या कोई भी ऐसा custom. For example, there is a custom that in government departments, people who belong to certain caste, they will be given a different chair. There is no legal sanctity, but it is a custom. So this custom is also violative of Article 14 and Article 15. Equality before law and religion, race, caste, there can be no. So any custom also, if it is detrimental to fundamental right, it will also be declared as unconstitutional by the Honorable Supreme Court or even High Court. Now this says, laws in force includes the laws passed or made by the legislature or other competent authority in territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or part may not be in operation. कह रहा है, any law which may not be even operation, that also will be void for violating basic structure. So, yani ki the Constituent Assembly, the founding mothers of the Constitution wanted to give a clear message in a very expanded horizon. कि भैया फंडामेंटल राइट बहुत ज्यादा सैंक्टिफाइड हैं, उनको वायलेट, डू नॉट वायलेट देम. एंड लास्ट में अब ये देखिए, फर्स्ट आई विल शो यू 4 लिखा हुआ है. ये क्या है? नाउ द पार्लियामेंट आफ्टर द 1971, व्हेन वाज गोलकनाथ जजमेंट केम? 67. तो किसको बुरा लगेगा? हु विल फील बैड? गवर्नमेंट. So, एक amendment जोड़ा, nothing in this article shall apply to the amendment of this constitution made under Article 368. यानी the term law does not include constitutional amendment. और एक और जोड़ा, वो भी देखते हैं. जब टेक्नोलॉजी है तो क्यों नहीं यूज करें? So the judgment of Supreme Court in Golaknath case restricted the power of Parliament. So who will get sad about that? Huh? Actually the government, because most of the bills are public bills, na? बिल्स का मतलब समझते हैं? Okay, so we have now the Supreme Court is restricting the power of Parliament. So we'll see a very important article, that is 368. Not required here, but still, since we are talking, we have the liberty, so we can use it. Okay. Okay, see this. Now the Parliament, to remove any doubt, कोई confusion नहीं आना चाहिए कि he says ना, गद्दी का क्या रूल है, और सबसे आखिरी रूल है कि हम रूल कभी भी बदल सकते हैं. So the Parliament attempts to do exactly the same. Okay, it is adds for removal of doubts. यहां तक लिख दिया, for removal of doubts. It is hereby declared that there shall be no limitation whatever on the constituent power of Parliament to amend, add, variation, repeal the provisions of this Constitution. यानी कोई डाउट ना रहे. अभी इसका क्या हुआ वो भी देखेंगे. ये क्या लिखा हुआ है? 2. Now we'll see. No amendment of this Constitution made or purporting to have made under this article or whether 42nd shall be called into question in any court. और यहां क्या लिखा है? Nothing in this Article 13 shall apply to amendment under this article. यानी the term law in Article 13 does not include constitutional amendment. ये है 1 और ये है 2. Okay? Now Supreme Court says clause 4 or 5 में, clause 4 and 5 were inserted by 368 42nd constitutional amendment, and this section has been declared invalid by Supreme Court in Minerva Mills case. Why? Because Supreme Court says कि ऐसा नहीं हो सकता है. You're getting my point. So we should not go this deep, but you just understand what is the crux of Article 13. Article 13 का crux, first, any pre-constitutional law cannot violate fundamental right. Any post-constitutional law cannot violate fundamental right. If they violate fundamental right, they will be void to the level of contravention or inconsistency. Later on, the term law in Article 13 includes ordinances, bylaws, customs or usage. कोई भी ऐसी चीज जो चली आ रही है तो चली आ रही है. पर you must understand, in a country with a written constitution, customs and usage and all these traditions play a very limited role. In United Kingdom, there is no written constitution, so customs play a very wide role. So this is the interpretation of Article 13 of the Constitution. Please write Article 13. Bylaw is a local regulation. एक दो question ले लेते हैं. Okay. So bylaw is a law made by a local authority. Okay. They sometimes ask chronology. Yes, they ask chronology. Okay. Persuasive judgment. Persuasive judgment matlab you can quote the judgment of Chennai High Court in Karnataka, but you cannot make it binding on Karnataka High Court. You can just say, my lordship, a similar case, a similar judgment has been given by Chennai High Court, but you cannot say that this is binding. But if the similar judgment is given by Supreme Court, it will be binding on High Court. And if you quote that, okay. So please write Article 13. Article 13 can be classified into two parts. Article 13 can be classified into two parts. A, pre-constitutional laws. A, pre-constitutional laws. B, A, pre-constitutional laws. B, post-constitutional laws. Pre-constitutional laws. B, post-constitutional laws. Please write. So you must understand, please write, pre-constitutional laws, pre-constitutional laws, pre-constitutional laws that are inconsistent with fundamental rights, pre-constitutional laws that are inconsistent with fundamental rights, pre-constitutional laws that are inconsistent with fundamental rights shall be, you, one of you please tell me, I'll be very happy if you say, shall be void to the level of inconsistency. Please write, shall be void to the level of inconsistency. Next. Okay, actually there are few doctrines also. We will definitely do them when we do judiciary. Because you are intellectually उस level पे जाएंगे तब मजा आएगा. अभी उसको नहीं करेंगे. Then you have, please write, post constitutional laws contravening post-constitutional laws contravening fundamental rights, post-constitutional laws contravening fundamental rights shall be void to the level of contravention, shall be void to the level of contravention. Shall be void to the level of contravention. In Information Technology Act, Section 66A, year 2000, declared unconstitutional. So, if अगर नहीं करना चाहिए तो सुप्रीम कोर्ट का क्या काम है? गलतियां, टेक्सास वर्सेस फेडरल गवर्नमेंट, फ्लोरिडा वर्सेस फेडरल गवर्नमेंट, न्यूयॉर्क वर्सेस फेडरल गवर्नमेंट. सो कैसे पता चलेगा? ये बताइए, पता कैसे? आपको लग रहा है when two people fight, one think that I am right, other thinks that he is right, and nobody is perfect, one of them is nobody. Okay, so the point is कि कैसे पता चलेगा? If there is a federal setup, there is always a requirement of independent judiciary. It is not United Kingdom, जहां you are crossing the road, if they see you, they will stop and say. And the purest thing is, civilization does not have an independent judiciary. Judiciary cannot declare a law made by parliament as unconstitutional. Still, parliament never makes a law that is against the concept of liberty, equality and fraternity. This is the level of civilizational maturity, but with a population 2% of what we have. So that also should be taken into, with 134, 140 crore people behaving in an orderly fashion is something which is very, very tough. There is resources are limited. There will be competing claims. There will be friction. They will, without a shadow of doubt. Still, we are going this strong. That reflects the beauty of this country. The soul is very strong. Otherwise, dispute होना ही होना है. इसमें कोई दो राय नहीं. पर collectively there are, what Dr. Ambedkar said, that dispute should be solved through constitutional means, not through civil disobedience or non-cooperation. Next part you write, did you write after level of contravention के बाद कुछ लिखा? नहीं, लिखे. The term law includes ordinances, bylaws. The term law includes ordinances, bylaws, customs, usages, etc. Customs, usages, etc. Okay? So, usages, etc. Now you write a Trinity कहते हैं, Jewel, Jewels of fundamental right. अच्छा, एक fundamental right ऐसी है, there is one such fundamental right, उसके बारे में scholars say कि if you delete all the entire article, if one fundamental right is there, it can give birth to all other rights. Article किसने कहा? 21. That is right to life, right to clean environment, right to reputation, right to speedy trial, right to healthy environment, right to access clean air. मतलब it can be extended. And there are 3 rights which are said, तीनों सगी बहनें हैं. 14 rights मैं बोल रहा हूँ. 14, 19 and 21. ये तीनों rights are like clone sisters, जुड़वा. Okay. So, and they walk hand in hand. So, 14, 19 and 21. First such right is, now 2021 prelims question. बहुत ही खूबसूरत और conceptual question पूछा. I wanted to show the paper. Actually, paper I am downloading and I cannot show from a private source. फिर वही clip डाल के. So, they are writing. Vanya Francis, Yuvraj, Shiv Narayan Tiwari, Shashidhar Pathak. Okay, they are answering. Okay, so the point is that what you call 14, 19 and 21. See, we can, UPSC website they do. I will bring a question. They asked a question, a very easy question. Whenever you see a very long paragraph in UPSC, it is a thumb rule. 98% of the time, it is the easiest question in the question paper. Either the statement would be absolutely correct, or most of the time there would be an impossible term given in the statement. The moment you eliminate, you get a right answer. So getting many a times UPSC, for example, I'll take you to a question. UPSC gave a statement that one politician contested from 3 constituencies in 1991. You only tell me, is it possible for anybody in the country to remember that which politician contested from 3 constituencies? क्या यूपीएससी आपसे एक्सपेक्ट करती है कि आप याद रखें कि किस किस पॉलिटिशियन ने कहां कहां से चुनाव लड़ा था? तो व्हाट यूपीएससी वांटेड यू टू एलिमिनेट द अदर 2. फर्स्ट स्टेटमेंट वाज इन अ बाई इलेक्शन द कॉस्ट इज बोर्न बाय द कैंडिडेट. अगर बीच में बाई इलेक्शन हो जाता है तो कैंडिडेट खर्चा देगा. ये तो कॉमन सेंस है, वो क्यों देगा? So you will eliminate that statement. Another basic fact which is known that a person can contest from 2 constituencies simultaneously. ये भी एक statement था which you, so you eliminate these 2, you'll get a brute fact. So then you will get an answer. So many a times they are giving an impossible statement which they know that you don't know, but you have to arrive by elimination. क्योंकि ऐसा कोई फैक्ट जो यूपीएससी एक्सपेक्ट नहीं, कुछ पूछ दिया एक बहुत ही ब्रूट, दे नो कि यू हैव टू अराइव एट अ कंक्लूजन बाय एलिमिनेशन. ओके, नाउ आर्टिकल 14 सेज द स्टेट शैल नॉट डिनाई. सो द स्टेट शैल नॉट डिनाई टू एनी पर्सन. सो फर्स्ट थिंग दैट शुड कम इनटू योर माइंड इज आर्टिकल 14 is applicable both to citizens and non-citizens, and person also includes legal persons, corporations. Companies Act 1956 as amended says that there can be a one person company. Company is also a legal person. So the term any person has been expanded by the Honorable Supreme Court. It says the state shall not deny to any person. Yani this person includes, अब सुनिए एक छोटा सा एग्जाम्पल. ओके, there is an amendment to Citizenship Act. Okay, now UPSC ने 2021 10 अक्टूबर को एक क्वेश्चन पूछा. If there is a law on 10th October, if there is a law that violates the principle of equality and it is नहीं, equality लिखे बिना, it is discriminatory in nature, it favors someone, which of the following article will it be challenged under? और उसमें 14, 19, 21. So what will be the article? 14. ये क्वेश्चन 2021 का. Without using the term equality, they wrote almost everything. Another question they asked Internet of Things पे एक पूरा पैराग्राफ लिखा था 2 साल पहले. You go inside the theater, you switch on, suddenly the lights get on. एकदम easy. And the answer was Internet of Things. They know कि you have already panicked in the examination hall because एक साल से आप तैयारी करें. So they just want you to be absolutely cool whatever happens. Then you will get 3 to 5 questions do not require anything. So it first thing is now Citizenship Act. ठीक है? Citizenship Act, for example, in section, it was amended in 2019, section 2 was amended. Certain categories of people coming from certain countries were not treated as illegal migrants and they will be given citizenship under registration and naturalization. Okay, this was added. Now, the person who will be getting citizenship and the person who will not get citizenship, whoever comes from Pakistan, Afghanistan, Bangladesh, all of them are Indian citizens or not? पहले गौर से मेरी बात को सुनिए, देन यू विल अंडरस्टैंड आर्टिकल 14 कंसेप्चुअल पॉइंट ऑफ व्यू से. जिन लोगों की बात हो रही है, द एक्ट इज टॉकिंग अबाउट 2 काइंड्स ऑफ पीपल. वन, certain people who have come from Pakistan, Afghanistan, Bangladesh, belonging to certain religious communities, they will not be treated as illegal migrant under Foreigners Act and Passport Act. Are these people already citizen of India? No. And certain classes of people have not been given citizenship yet. उसमें एक और, फॉर एग्जाम्पल सर्टेन रिलीजियस कम्युनिटीज वर लेफ्ट आउट. प्रोटेस्ट इसीलिए था ना कि सर्टेन रिलीजियस कम्युनिटीज वर लेफ्ट. आर दे सिटीजन्स ऑफ इंडिया? नो. सो बोथ द कैटेगरीज आर not citizen of India. One is being given, other is not being given. So how are they challenging the law? By Article 14 it says the state shall not deny to any person equality before law or equal protection of laws within the territory of India, being a migrant, being an illegal migrant, being an... So Article 14 is universally applicable. आप कोई भी व्यक्ति हैं, मनुष्य हैं, सांस ले रहे हैं, Homo sapiens and taking breath, you will be coming under Article 14, whether you are citizen or not a citizen. So it has a very... बताइए सबसे अभी मैं सिटीजनशिप एक्ट खोल के दिखाऊं आपको स्टेटमेंट, अब क्या है के लिए दिल पे नहीं लीजिए, छोड़िए। तो मैं ये कह रहा हूं, सुनिए, इट वॉज एन ऑब्जेक्ट एंड रीजंस ऑफ द बिल द ऑनरेबल होम मिनिस्टर स्टेट दैट परसिक्यूटेड रिलीजियस माइनॉरिटीज, इन दोज परसिक्यूटेड रिलीजियस माइनॉरिटीज, हमारे यहां वो माइनॉरिटीज, हम उनको, हिंदूज आर माइनॉरिटीज इन इंडिया अंडर नेशनल कमीशन फॉर माइनॉरिटीज एक्ट 1992 सेक्शन 2, हिंदू है हमारे यहां माइनॉरिटी, उनके यहां परसिक्यूटेड रिलीजियस माइनॉरिटीज, उनके यहां के माइनॉरिटीज को हम दे रहे हैं, तो उसको क्या कर रहे हैं? दिस इज नॉट अ लीगल प्रोविजन, दिस इज जस्टिफिकेशन टू गिव देम। आर दे माइनॉरिटीज इन इंडिया? Hindus, are they minorities in India? The first community that is mentioned in section 2 is Hindu. Are they minority? Nahi. National Commission for Minorities Act 1992 empowers the union government under section 2 to declare minorities, and all the major communities have been declared minorities. Hindus are not minorities, and Jews have not been declared till date. The last community to be declared minority was Jains. Smart उतना ही बनना चाहिए, बिला वजह का। चलिए ठीक है। So the point is कि the point out here is कि who can challenge that law? अब इसका minority से कोई लेना देना ही नहीं है. What is the term we are talking about? We will see minority when we do Article 30. Okay. So what is we discuss in GS? What we discuss in GS is like a chef is being asked to prepare tea. मतलब it is not even one level, class 1 level. Okay, literally it is not. Those who have law optional, it is not even one level, 2 or 3 का level का पढ़ाई चल रहा है. Article 14, 12, definition. So in law, what we have studied exhaustively, this is 1 or 2 level. Okay, I don't want to go into the. ये कुछ नहीं है. This is just basic understanding of the Constitution. Article 14 itself is an article. More than 500 books are written only on Article 14. So आपको जितना पढ़ना है, that is more than enough. Okay. अब we will talk about, अब वही ज्ञान, प्रिंसिपल ऑफ नॉन रिफाउलमेंट, यूएन रेफ्यूजी कन्वेंशन 1961, अब उसी पे प्रिंसिपल्स ऑफ इंटरनेशनल लॉ पे 100 केस हो जाएगा. काहे के लिए बेला वजह का दिल पे क्यों लेना? जो यूपीएससी पूछेगी उसी पर कॉन्सेंट्रेट करना है. ठीक है. सो यू आर रिक्वायर्ड टू नो द प्रिंसिपल ऑफ आर्टिकल 14. फर्स्ट पॉइंट इज कि इट इज एप्लीकेबल टू ऑल पर्सन, इक्वालिटी बिफोर लॉ. और आपका तो सिलेबस कुछ है ही नहीं. आप किसी से, anybody doing law in the class, there may be 50 students who are doing online also. You ask them what is law optional and what is UPSC. ये पढ़ाया जाता है प्री नर्सरी में. What is Article 14? Okay, that is प्री नर्सरी लेवल का कोर्स है, क्योंकि you are not required to have that much understanding. Okay, so even in judiciary, I have seen, even in judiciary, I have taken 2 years only for judiciary students Indian Constitution. उनको भी कुछ नहीं. They want just one paper is Indian Constitution. उसको छोड़ के Indian Contract Act, CRPC, IPC, judgment writing in some states, so अलग है. ये तो Constitution का कह रहा है बेसिक. ओके, हाँ, पर बेसिक एकदम क्लियर होना चाहिए. इफ यू आर प्रिपेयरिंग टी, यू शुड नो द मैग्नीट्यूड ऑफ वाटर, एवरीथिंग. अब उसमें नहीं होना चाहिए जैसे एवरी आंसर इन दिस कंट्री, सो दे वो घुमा फिरा के, बिकॉज दे डोंट नो द बेसिक, कुछ बोल के आगे निकलना है. सो यू मस्ट बी वेरी क्लियर. सो नाउ लेट्स कम. द स्टेट शैल नॉट डिनाई इक्वालिटी बिफोर लॉ एंड इक्वल प्रोटेक्शन ऑफ लॉज विद इन द टेरिटरी ऑफ इंडिया. सो 2 messages that come out is this is applicable to all persons irrespective of their nationality. And second, those who are within the territory of India, and the Indian embassies and consulates across are also part of territory of India. Second point. Third point is equality before law and equal protection of laws. So what is there? If you will search on EPL versus EBL, okay, so EPL versus EBL, एक आपको हमेशा, you will on Google, you will see this, what you call it, this pictorial representation, कि 3 people are actually watching a cricket match. Okay, 3 people. This is one such picture which you will always see. So Rohit Sharma, for example, Virat Kohli. ठीक? Virat Kohli is at non-striker's end. Okay. So the point is कि you have three people. So this is common picture on Google. You will always get equality before law versus equal protection of laws. Now this person is watching the match. No, he is actually asking score and feeling good. Okay. This person somehow jumps, sees and goes back to his basics. Okay. And this person actually is enjoying and commanding these two that you drink Complan and come to my height. Okay. So the point out here is that the state shall provide a stool or a table or a bench to this person. And the state shall provide a relatively less thing to this person. And the state shall not be providing anything to this person. So the concept of equality before law is a British concept, and it is an important component of rule of law. So it is a negative concept. Equality before law means absence of special privileges. Yani everybody shall be equal before law, irrespective of the circumstances. It is a negative concept. The state is allowed not to make a positive discrimination. Irrespective of anything, if the state is providing stool, it will be provided to everyone. If the state is providing a bench or a desk, it will be provided to everyone. There will be no absence of special privileges. No special privileges. So that is equality before law. It is a negative concept. किसी को भी कुछ special नहीं मिलेगा. If anybody will get stool, all three of them would get stool. Now you have equal protection of laws. It is a positive concept. People who are placed in similar circumstances shall be treated similarly. People who are not placed in similar circumstances. So equality before law is a negative concept. State is not allowed to do something. Equal protection of laws, state is actually asked to do something. So equality before law is a negative concept. Equal protection of laws is a positive concept. In equality before law, there is no special privileges. Absence of special privileges. In equal protection of laws, there is a positive discrimination. People who are placed in similar circumstances. This is Supreme Court 16 November 1992 Indira Sahni judgment. People who are placed in similar circumstances shall be treated similarly. इस height के जितने भी लोग हैं, all the people of this height will be getting a stool, bench or table, whatever they give. People who are placed in similar circumstances shall be treated similarly, and people who are not placed in similar circumstances shall not be treated similarly. Second point, Supreme Court says protective discrimination is a facet of equality. So actually, when you are giving stool to this person, you are not doing some favor. You are just allowing him to be equal. So protective discrimination is also a facet of equality, reiterated by Justice Chanchud 1 month back. He was talking about Article 16 reservation. He said protective discrimination, किसी को कुछ extra इसलिए दे रहे हैं कि वो कम है, इसलिए नहीं कि उसको ज़्यादा बढ़ाना है. So protective discrimination is a facet of equality. And equality, likes should be treated alike and unlike should not be treated. Finally, the Supreme Court says people who are placed in similar circumstances shall be treated similarly, and people who are not treated in similar circumstances placed, they shall not be treated similarly. And first page of Mandal Commission, which I made you write on that day, that is that there is no equality among unequals. Unequals के बीच में कोई equality नहीं है. Somebody who went to DPS, somebody who is getting access to best of education, how can you compete? there is no equality among unequals. To equate unequals is to perpetuate inequality. Unequals को equate कर देना, perpetuate inequality. So there are two concepts, equality before law and equal protection of laws. Equality before law is a British concept. Equal protection of laws is an American concept. Equality before law is a negative concept. Equal protection of laws is a positive concept. Equality before law avoids any special provision. Equal protection of laws calls for positive discrimination. Always remember two terms: positive discrimination and affirmative action. Positive discrimination and affirmative action. Positive discrimination is you are not giving something extra. Actually, that person is not feeling well. You are bringing him at par with others. So it is not a sort of discrimination, negative, but it is a positive discrimination. There is no negative discrimination towards others. So positive discrimination, protective discrimination is a facet of equality, and equal protection of laws ab aate hain. Believe me, when this Citizenship Act was passed, one of the leading lawyers of the country, Harish Salve, okay, he gave an interview. Before starting the interview, I was dead sure ki first statement what he will be saying. The moment I thought and I watched the interview, the first line of argument he gave was the same. Certain, for example, in Citizenship Act, Hindus, Hindus, Sikhs, Buddhists, Parsi, Jains who have come from Pakistan, Afghanistan, Bangladesh, they will be given. They will not be treated as illegal migrant, and they will be given citizenship by naturalization and registration. Okay, ये Citizenship Act में 2019 amendment करके डाला. So the reporter asked the first question, how do you justify? And Harish Salve has been defending the government. He is one of the leading, he's Queen's Counsel actually. So he has been one of the greatest lawyer of our time. Okay, and Falias Nariman, of course, he's the constitutional expert. He says, Article 14, now we'll see Article 14 and then we'll understand. Article 14. पूरी की पूरी लड़ाई सिर्फ एक लाइन की है. Now you'll understand. If you read the language of Article 14, just give me one answer. Does it permit reasonable classification or not? समाज का वो, I'll speak in Hindi, then speak in English. समाज का वो वर्ग जो दूसरे वर्ग से अलग है, क्या उसको अलग तरीके से ट्रीट किया जा सकता है? That section of society which is different from other section, can it be treated differently? Yes, it can be treated differently or not. So the point is, it can be treated differently. So the point out here is कि he says that treating those communities, Hindus, Buddhists, Parsis, Jains, Sikhs who have come from Pakistan, Afghanistan, Bangladesh, पूरा का पूरा सुप्रीम कोर्ट में पूरा केस एक पॉइंट पे टिका है. Article 14 permits reasonable classification or not? पूरी की पूरी लड़ाई इस बात की है. The entire discussion would be कि reasonable classification is permitted in Article 14. Whether to treat these communities as a separate bracket is a reasonable classification or not. So the law has, it has been challenged in court. Whenever the Supreme Court takes the law, the only question that needs to be settled is कि whether treating these communities coming from Pakistan, Afghanistan, Bangladesh as a separate entity than others is a reasonable classification or not. So Article 14 में क्या समाज के अलग अलग वर्गों को अलग अलग तरीके से ट्रीट करने की इजाजत देता है या नहीं देता है? बिल्कुल देता है. It permits reasonable classification. Every time there is a discrimination, Supreme Court asked only one question, whether it is a reasonable classification or unreasonable classification. So this particular thing related to Article 14 of the Constitution, that it is a reasonable classification. So you are getting my point. So Supreme Court में क्या पूछेगा? When this law, सुनिए, एक law है, it has given citizenship to certain people. It tries to give citizenship to certain people and declares them as not an illegal migrant, while one community is left out, for example. So what the government will be arguing in the court? That this is a reasonable classification. These communities are persecuted minorities in their respective countries. So the court will only check that whether reasonable classification है या नहीं है, because Article 14 permits reasonable classification. So for example, article, you are getting some SC/ST scholarship. So the people who have been our brothers and sisters from communities, they have been relatively deprived. So it is there is just by virtue of being born in a family, certain class socio-economic discrimination is there. So definitely if a scholarship is given, that is perfectly a reasonable classification. So every time there is a state treats people differently, the court checks whether it is violative of article. If it is a reasonable classification, it is fine. If it is not a reasonable classification, it is not fine. So Citizenship Act is perfectly valid. You know, any law passed by parliament is absolutely valid till it is declared as invalid. And most importantly, the onus lies on the person who has challenged the law to prove whether it is valid or invalid. ये किस पे कौन prove करेगा? Who will prove? The person who has challenged, he has to prove. Like when the police accuses you, the onus lies on whom to prove that you are guilty. Onus is on the people, other than certain laws. So onus is on the police, not on you to prove yourself guilty. You will be presumed as guilty until you are until you are proved beyond reasonable doubt that you have been guilty. You will be proved as taken as innocent. So Article 14 के 4-5 आयाम है. First, it is applicable to everyone, citizens, non-citizens, companies, legal corporations. Second, within the territory of India, that territory has a wide extension, includes the India's embassies abroad. Third, this is equality before law is a British concept, is a negative concept, it is absence of restraint, and it is also a part of rule of law, one of the major element of rule of law. And second, equal protection of laws is an American concept, and it is a positive concept. It permits reasonable classification. Any classification which is reasonable in the society, like should be treated alike, unlike should not be treated alike. And this is the basis why the Parliament of India went ahead and provided for treating certain people not as illegal migrant while others as illegal migrant. So this is, we will again see article, most important article and beautiful article is 15 and 16. Huge amount of confusion is there. We'll see them after 14. So please write. Kya? So Indian embassies abroad. So embassies are called Vienna Convention 1969 section 7 and other sections. Indian embassies are treated as islands of foreign territories. जो US embassy है शांति पथ पे, you have US, you have Australia, opposite we have our best friend Pakistan. So उसी lane पे you have all the friends and best friends. Okay, so you have, so the point is कि embassies there, inside the embassy whose law would be there? I'll give you an example. One of the person who was guilty, he was inside the Edward Snowden or क्या नाम था? He was inside the embassy of a country for 3 years in UK. Somebody who was for certain leaking certain files of US government, there was a case against him against sexual harassment or something. Actually, the case was said to be just because he leaked certain confidential documents of government. So he was inside the territory in United Kingdom. He took asylum inside the territory of a foreign country. So UK Scotland Yard was waiting outside for 3 years. They cannot enter inside and arrest because these embassies are islands of foreign territories where the law of their domestic country, no, as per Vienna Convention, you cannot enter. When Nasheed, he was one of pro-India, so he was in Maldivian government, there was coup, so we provided him asylum for 3 days inside the Indian embassy in Malé. So the police cannot, there have been 100 such cases where the people have been given asylum inside the embassy. And once they are given an asylum inside the embassy, उसके बाद बाहर वेट ही करना है. अगर वो खुद से निकला तो निकला, नहीं तो you cannot enter the, because these embassies and consulates are islands of foreign territories, वहां उनके domestic laws चलेंगे. इसमें territory of India also includes these. When we see the territorial, extraterritorial legislative powers of parliament, then we will see कि कैसे, today only I was teaching federalism in other batch, today only. So this कि how the parliament can legislate for Indian citizens and their property abroad. अभी लिखिए article 14, equality before law and equal protection of laws. The principle of equity. Okay, somebody is saying if all are equal, then what about reservations in society? Of course, all are not equal. Equity, principle of equity, of course, without a shadow of doubt. Both principle of equality as well as equity. If the Constitution of India only has equality before law, then अगर Constitution में सिर्फ equality before law रहता, तो क्या state discriminate कर पाता? No. So we have equity principle also and equality principle. Equity का मतलब है give what she or he deserves. So everyone, what is justice? Is justice a relative concept? Yes. Justice will be done if two people, one person has committed crime because he was in a fit of rage, because of a reason, and some person who did a cold-blooded murder. So do you think that justice will be served equally? They must, circumstances are also an important factor. Okay, few more questions after good evening. Up to good, you have? Okay, just a second. So, okay, right. This is like not working. Please write Article 14, equality before law and equal protection of laws. First, you write Article 14 is applicable both to the citizens, non-citizens, legal persons like statutory corporations, companies, etc. Companies, etc. Then you write equality before law is a British concept. Equality before law is a British concept which has following connotations. Equality before law is a British concept which has following connotations or following features, meanings, कुछ भी लिख दीजिए. Put a dash and semicolon. Okay. A, absence of any special privilege. Absence of any special privilege. B, equal treatment before. Absence of any special privilege. A. B, equal treatment before. Absence of any special privilege. ये पहला था. दूसरा है B, equal. What did you write? Equal treatment before ordinary laws of the land. Equal treatment before ordinary laws of the land. C, no person is क्या होना चाहिए? Above the law. No person is above the law. Okay, we'll write a paragraph, then again we'll come to it. Please write further. Equality before, change the line and write with a new statement and vigor. Equality before law is an important component of rule of law. Equality before law is an important component of rule of law. Full stop. Rule of law was propounded by equality before law is an important concept of rule of law. Rule of law was propounded by A.V. Dicey, D-I-C-E-Y. A.V. Dicey. A.V. D-I-C-E-Y. A.V. Dicey. Full stop. Now you write, the major elements of rule of law are A, absence of arbitrariness. The major elements of rule of law are absence of arbitrariness. B, equality before law. Equality before law. C, rights primacy. Rights primacy. Equality before law, rights primacy. Okay, full stop. Just a second, I'll take 2-3 questions they have said, although you must forward over there. First of all, sirs, equality before law and equal protection have different. Why or is placed between them or not are? Rights primacy. Okay. So, or because both. Sir, why we have both equality before law? Why do we have both equality before law or equal protection of laws? Because in criminal offenses, many matters there is equality before law. Jaise criminal law, a rich man murders, a poor man murders, same. Okay, so in many matters it is equality before law, but at the same time, equal reasonable classification is also permitted. Kya criminal laws uniform? Do we have uniform criminal laws in India other than Article 371A and 6th schedule? Certain criminal provisions given to autonomous district councils. Do we have uniform criminal code in India? Yes, we do have. IPC is equal subjection of all poor. So we do not have. Do we have uniform civil laws in India? Without a shadow of doubt, yes. But in marriage, adoption, divorce, maintenance, we don't have. But in other matters, Motor Vehicle Act, Land Acquisition, so do we not have civil laws as uniform? We have civil laws and uniform, but in personal laws, we do not have uniform civil laws. But we have civil laws also uniform, we have criminal laws also uniform. But some civil laws dealing with personal matter, adoption, maintenance, inheritance, divorce and all, we do not have civil laws. Muslim Shariat Application Act 1937 and other provisions. Okay. So why we have both? Because both positive discrimination. Just a second. IFS officer Dibyani Kharboje case. Dibyani Kharboje was a 1997 batch IFS officer, and she actually took a maid from here to New York. She was posted on dual posting. She was also in Indian embassy and she was also as Indian representative in United Nations. The maid complained to the authorities that she does not pay minimum wages act as per the US laws. Okay, so on one fine morning, and she was arrested by the police, which was a very, very serious thing because it was our prestige. Na? She was enjoying the diplomatic status. So government came down heavily. It was 2013 case, and the US was forced to withdraw all the cases and she returned back to India. Okay, because she was given diplomatic immunity which they were not accepting, so these confusions do happen. Okay, फिर वही बात है ना कि law है तो जरूरी थोड़ी है कि follow होगा. There would be certain aberration. That so many times they are irresponsible. What Supreme Court will do on this? What is the? We do have a Supreme Court to decide. Okay, so this case is of Debyani Kharboje. Then territories of India includes in a message. Why not included in Article 1? Because this is related territories of India in where they have specifically mentioned. India, that is Bharat, shall be a union of states. कह रहा है वहां पे. यहाँ the territory of India comprised of states, UTs and other territories acquired time to. वहां लिखा है embassies. What about High Commissioner? In Commonwealth countries we send High Commissioners. In non-Commonwealth countries we send ambassadors. Very simple. In recent news, Pak search in embassy of other country. Of course, it is a violation of Vienna Convention. Is fundamental rights can be applied to all human beings? All human beings within the territory of India, not all fundamental right, but Article 14. How reservation? Reservation will do. It's a very High Commissioner also included. Sir, High Commissioner also. You may explain again. I'm confused from the why they are taking. Okay, ठीक है? Geneva Consent. So of course, convention is violated. Okay. Now you just read out your what did you write? Then we'll again see. The major element of rule of law. One. Absence of arbitrariness. मतलब law should be. अब सुनिए कितना rule of law. Just a second. Rule of law means it is lex is rex. Law is the king. अब law कह रहा है कि the one who wears white shirt will be hanged. So there is a law, but it is not reasonable. It is arbitrary. So first rule of law का पहला component है कि law होना चाहिए और law arbitrary नहीं होना चाहिए, reasonable होना चाहिए. Law must be reasonable. Second, equality before law. Anybody who wears white shirt will be hanged. Blue shirt will not be hanged. Again, there is no equality. Just by having rule of law is not enough. Law should be reasonable and everybody should be treated before law in equal manner. Third, rights. The rights of the people should be secured so that the government does not behave in a totalitarian manner. Okay. So, equality before law के परदादा का नाम क्या है? जिनका वो बच्चा है, 3 में से 1 बच्चे, या पिताजी का नाम क्या है? रूल ऑफ लॉ के 3 बच्चे हैं, उनमें जो सबसे जिसने नाम कमाया उस बेटे का नाम है इक्वालिटी बिफोर लॉ. इज एन इंपॉर्टेंट कंपोनेंट ऑफ रूल ऑफ लॉ. बट रूल ऑफ लॉ इज इनकम्प्लीट बाप भी बेटे के बिना इनकम्प्लीट है. Rule of law is just having rule of law कुछ नहीं होगा. Law should also be equal. There should be rights and law should be reasonable. Otherwise, just by having rule of law में तो कुछ भी लिख देंगे. Okay. Now you first paragraph you read, then we'll go on a break. इससे पहले जो लिखा है rule equality before law के 3 आप पढ़िए चलिए. आर्टिकल 14 इज एप्लीकेबल नहीं, जो रूल ऑफ लॉ का 3 आप इसका जो लिखा है इक्वालिटी बिफोर लॉ का 3 लिखा है. हाँ, रूल ऑफ लॉ. ओके फत एब्सेंस ऑफ. So what is this? This is also promoting a sense of equality. So we come back. First we will write the American concept, and equality before law is a British or American concept? British concept. We will write equal protection of laws. Article 14 से questions easy आते हैं. Trap होते हैं Article 15 और very I will ask a question. I'll give you 1 day also. Okay, I'll ask a question. I'll give you 1 day also. ठीक है? So 15 and 16 we will see what is and what kind of questions have been asked. Okay, we'll see 15 and 16. First we'll write 14 complete. ठीक है? और ये सब question in UK UCC will be applied. How equality before law is a negative concept because it prohibits discrimination. There is no end to how Pakistan and North Korea raided in embassy. This will be asked in UPSC. How Pakistan is raiding an embassy. जो आ रहा है क्वालिफाई करना है ना, तो उसी पे कॉन्सेंट्रेट कीजिए. ओके, राजेश्वर इज आस्किंग अ क्वेश्चन. व्हाई डू वी हैव बोथ इक्वालिटीज बिफोर लॉ एंड इक्वल प्रोटेक्शन ऑफ लॉज? प्लीज टेक योर सीट. इक्वालिटी बिफोर लॉ प्रिंसिपल इज एप्लीकेबल इन सर्टेन सर्कमस्टांसेस. ओके, प्लीज टेक योर सीट. सो the principle of equality before law is taken in certain circumstances, while the principle of equal protection of laws is taken in certain circumstances. That the principle of equity reservation is provided in. So the principle, see, whenever you make a mistake, you always tend to make 5 more to correct that. So getting my, if you make a mistake, just be calm, accept, and then no problem. इसके लिए इन्होंने सोचा जल्दी से अंदर जाते हैं आराम से. So we have, see, please listen. Equality before law is applicable in certain circumstances. For example, criminal laws. Anybody who belongs to any religion, caste, race, any gender, anything, she or he shall be subjected to same laws. If you commit murder. Okay, so equality before law is, for example, the state is making so thousands of such laws are made. So they are uniformly. Maternity Benefit Act, Right to Education Act. Okay, so there are so many laws which are made which are equally applicable. In those, the principles of equality shall be there. But equal protection of laws principles would be there in reservation. So many principles. One. Second, for example, the state is DDA, now Delhi Development Authority. Land is not a state subject not within the prerogative of the Legislative Assembly of Delhi. So DDA, whenever DDA comes with housing schemes, you know this, first you need to deposit 50,000 or 70,000 rupees. After that, if your name comes in the lot, you are given, you are allocated. In that also, there is a provision of reservation. So actually, there is a provision of reservation. So actually, the state is providing certain privileges to certain classes. So equal protection of laws provisions comes in those areas where the state needs to treat people differently. Now, Prime Minister's 15-point program, UPSC ka question for minorities. Pre-matric, post-matric scholarship for minorities. This was challenged in Supreme Court. Thus, pre-matric, post-matric scholarship for minorities. Minorities determined on the basis of religion. कैसे आप दे सकते हैं? Minorities determined on the basis of religion. How can you give? This was challenged in Supreme Court. Said this is reasonable classification under Article 14. So, court will decide to. Ab jaise the people who are challenging Citizenship Act, they will come to principle of equality before law, and the people who are supporting, they will take the refuge of equal protection of laws. So the court will decide that whether this is a reasonable classification permitted or not. So this is an answer, Rajeshwar Singh. Okay. So when one question, equal treatment before the ordinary laws of the land. यहाँ ordinary law का मतलब ordinary statutory law नहीं है. यहाँ ordinary law का मतलब any law which is equally applicable to everyone, that is constitution. Here that 99% of the time ordinary law means statutory law. Here ordinary law means any law which is equally applicable to everyone. It can be constitution also, it can be a statutory law also, it can be a rule also. Now the second part of article 14 is equal protection of laws. Equal protection of laws is a positive concept or a negative concept? Positive content. Like should be treated alike and unlike should not be treated alike. People who are placed in similar circumstances shall be treated similarly. Please write second part. Equal protection of laws. Aditya Pandey, I think you got the. Sir, is it possible to give equality to those who are not the resident of India? Of course, under Article 14, everybody is covered, even a non-resident, but within the territory of India. Please write. Equal protection of laws is an American concept, wherein equal protection of laws is an American concept wherein people who are placed in similar circumstances shall be treated similarly. People who are placed in similar circumstances shall be treated similarly. And people who are placed in similar circumstances shall be treated similarly. And those who are not placed in similar circumstances shall not be placed, those who are not placed in similar circumstances shall not be treated similarly. Full stop. Thus, equal protection of laws promotes the principle of equity. Thus, equal protection of laws promotes the principle of equity. And reasonable classification. Okay? Any classification by the state, must not be artificial. Any classification by the state must not be artificial or unreasonable. Must not be artificial or unreasonable. Okay? Now थोड़ा Constituent Assembly की debate पे कुछ एक दो line लिख लेते हैं. When Article 14 was being debated, first how the Constitution was prepared. First there was a draft committee which actually summarized everything and then placed before the Constituent Assembly. Most of the articles were added without voting. 90% of the articles in Constituent Assembly were incorporated without voting. Why? ज्यादातर प्रोविजंस कॉन्स्टिट्यूशन में बिना वोटिंग के कॉन्स्टिट्यूशन में ऐड किए गए कॉन्स्टिट्यूएंट असेंबली के द्वारा. क्यों? हाँ, एक मैसेज देना चाहते थे दुनिया को. वी वांट टू गिव अ मैसेज टू द वर्ल्ड दैट दिस इज बाय कंसेंसस. This is the Constituent Assembly is not deciding over things by voting. So if there, for example, India or Bharat debate, so they said, okay, India, that is Bharat shall be a union of states. So actually added both. कहीं भी ऐसा distinction आया, wherever it came, many a times they were adamant. For example, some of them wanted to add socialist in the preamble. So Constituent Assembly में one member said, why are you giving a message to the world that we are socialist. It is like you said that somebody is like, he will say ki okay, I felt matlab I should not have done on that day, and I later on regretted. He will say everything, but he will not say I am sorry. So without saying I am sorry, he has actually accepted his mistake. But you want ki nahi, sorry bolo wo bhi पैर छू के. So it is like the term socialist was not added in the preamble, but the idea of socialism was shining in directive principles. So the Constituent Assembly, most of the time they have added the provisions by consensus. Dr. Ambedkar used to stand, explain, and then most of the time. There were few instances where they could not actually, so voting, otherwise it is consensus. Okay. Now it is on the principle of equity. Actually, we must write a small paragraph कि Article 14 का क्या-क्या connotation in the light of Supreme Court judgment or Constituent Assembly debate. Please write. Article 14 is a substantial Article 14 is a substantial provision that actually promotes the idea of political democracy, that actually promotes the idea of political democracy, and at the same time that actually promotes the idea of political democracy, at the same time it promotes the idea of justice. Promotes the idea of justice, giving one what she or he deserves. Giving one what she or he deserves. Justice. Giving one what she or he deserves. Full stop. Then you write, promotes the idea of justice, giving one what she or he, छूट गया आप लोगों का, नहीं, deserves, full stop. लिखिए. Reasonable classification has led to wide positive discrimination. Reasonable classification has led to wide positive discrimination where the state led to wide positive discrimination. Reasonable classification has led to wide positive discrimination where the state promotes the interest of diverse sections. Led to positive discrimination where the state promotes the interests of diverse sections in a diverse manner. Full stop. Then you write the principle of equity. The principle of equity is of uttermost significance. The principle of equity, EQUITY, is of uttermost significance. The principle of equity is of uttermost significance in our country, where diversity and inequality is broadly witnessed. broadly witnessed, full stop. Thus, EBL, equality before law, short में लिखिए capital letters में. Thus, EBL can be witnessed in criminal laws. EBL can be witnessed in criminal laws. Criminal laws. While EPL promotes the interest of, while EPL promotes the interest of marginalized sections, promotes the interest of marginalized sections to achieve, promotes the interest of marginalized sections to achieve an egalitarian order, मतलब equality based order. Marginalized sections promotes the interest of marginalized sections to achieve an egalitarian order. ठीक है, अगर आर्टिकल 14 पे कोई आता है, so you will write all these things, you will get the best possible marks. We will see article 15. उसको शुरू करने से पहले first thing is just a small example. I'll show you the constitution in fact, because 15 में it's not that simple. Two basic things I'll show you, then we will see what is article 15. Article 15 पे एक movie भी बनी थी. Okay. There is always a space at the top. सर मेरा झूठ गया. Okay. So please see, dear student, it says only two things. सब बाकी की कहानी में कोई दम नहीं है. The most important distinction is the state shall not discriminate. The term shall means compulsorily. Shall not, UN जब Paris climate deal हो रही थी, Article 12 of Paris climate deal, they added the word shall. Developed country shall. उसको लेके 12 घंटा मीटिंग चली. बाद में उसको रिप्लेस करके should जोड़ा गया. So every term that is there is actually a, so the state shall not discriminate against any citizen. So second message here is Article 15 can be enjoyed only by citizen. Not like Article 14 was a bhandara. This is not a bhandara. Okay. This is a private resort. Okay. So on grounds, the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth. So religion, race, caste, sex is a biological, we all know, biological distinction, while gender is a sociological distinction. Very simple. Any human beings, by virtue of being biologically human, they are born with certain biological traits, while men and women have different biological traits by birth. So that is a biological distinction, that is sex. While gender is any sociological construct. Society expects the women to have long hairs, or the society expects the women to take care of the children alone. Any role that is given to a sex by virtue of society is a gender based. Like women should be cooking, or for that matter society expects them to work. Who told that women will be having short hairs? At the time of birth, both of them have. So who told that women shall be taking care of the children? Society. So actually, and it is deeply entrenched, itna deeply entrenched, a very mention of it is actually so it is deeply entrenched. So any role that is given by the society, not by God. There is a biological distinction between male and female, so that is there. Beyond that, any distinction is a gender construct, but the constitution consciously uses the term sex, not gender. Okay. So you have religion, race, caste, sex, place of birth. So, okay, now you just saw Article 15. Always 15 and 16 is done differently, but I always do together because of certain reasons. Religion, race, caste, sex, place of birth. Article 16 में क्या है भाई? No citizen on the grounds of religion, race, caste, sex, descent, place of birth or residence. So what are the two additional grounds? Descent and residence. ठीक है? So descent and residence. Now we'll come. Okay. Article 15 and Article 16. First of all, pen to aeroplane. From needle to aeroplane. Everything is covered under Article 15 except public employment and reservation in promotion. If you are getting admission into IIT, Central University of Hyderabad or University of Delhi through reservation, it will come under 15 or 16. Huh? Abhi bola, from needle to aeroplane, everything comes under 15 other than public employment and reservation in promotion. ये सब, ये बहुत बड़ी 15 और 16 में सब रटा हुआ है, लेकिन दो तीन कंफ्यूजन 99.9% है, because they don't read the constitution. Now I am again saying, everything from needle to aeroplane is covered under Article 15 except in public employment and reservation in promotion. So if you take admission in IIT, it will be covered under 15 or 16. Huh? Huh? अभी रुकिए आ रहा. ओके, इट इज 15 और 16. हाँ, आप आईआईटी में एडमिशन ले रहे हैं तो नौकरी ले रहे हैं, तो वो 15 में कवर होगा कि 16 में होगा? रुकिए. If somebody is appointed as assistant professor in IIT Delhi, it will be covered under 16 or 15? Huh? 15. 15 और 16. अच्छा, कितने लोग कहते हैं 16? अच्छा, कितने लोग कहते हैं 15? एक आध. पब्लिक गेटिंग पब्लिक एम्प्लॉयमेंट, दोनों चीज, मैटर्स ऑफ पब्लिक एम्प्लॉयमेंट एंड, यही सब तो कंफ्यूजन है, इसीलिए तो आप आए हैं. ओके, सो द पॉइंट इज आर्टिकल 16 डील्स विद पब्लिक एम्प्लॉयमेंट and reservation in promotion. Article 16 deals with public employment and reservation in promotion. So a person being appointed as assistant professor IIT Delhi, so will he be coming under through reservation? It will be covered under 16 or 15. Public employment है या नहीं है? है, so it will be covered under 16. A child getting admission through reservation, will it be covered in 15 or 16? 15 or 16? 15, because everything from needle to aeroplane is, यही तो मैं फिर से बोल रहा हूं, मरते वक्त भी यही बोलूंगा कि नीडल टू एरोप्लेन इज कवर्ड अंडर 15, ओनली पब्लिक एम्प्लॉयमेंट. तो आप कॉलेज में एडमिशन लेते हैं, आईएएस की डिग्री मिलती है, आईएएस का पीडीएफ मिलता है, पब्लिक एम्प्लॉयमेंट है. बस सिविल इंजीनियर बनते हैं, टीसीएस जाते हैं, यही होता है ना. हाँ, ऑल द सिविल इंजीनियर्स आर इन आईटी सेक्टर. ओके, so actually IT sector is employing, सब का मालिक एक है. Okay, so they are employing everyone. Okay, so you must be having friends. So the point, even biotechnology engineers are employed by TCS. Okay, and SCL also is, they both are competing to employ greater BA history also. So the point is in IT sector. So the point is ki, the point out here is ki, if you are taking admission in IIT, will it be covered under 15 or 16? 15. If you are being appointed as an assistant professor in IIT, will it be covered in 15 or 16? 16. If you are given promotion in the post in public employment, then it will covered under 16 or 15? 16. Everything on earth covers under 15 other than public employee. ये पहला confusion. दूसरा confusion. Okay? There is a university in Delhi, that is Ambedkar University Delhi. aud.ac.in, ये उसकी वेबसाइट का नाम है. ठीक है, नाम सुना है यूनिवर्सिटी का? ओके, इट इज अ स्टेट यूनिवर्सिटी. 85% सीट्स आर रिजर्व फॉर दोज हु हैव डन देयर क्वालिफाइंग एग्जाम फ्रॉम दिल्ली. ये सुना है? समझते हैं, बिना प्रैक्टिकल के नहीं, फिर वही होगा जो ओल्ड राजेंद्र नगर में है. Okay, so the point is 85% seats in this. So if, for example, if you have done BA Honors English from Delhi University, okay, then you apply for MA Development Studies and you apply for MA Environmental Studies. Okay, okay. So you have done your qualifying exam. What is the qualifying exam for Development Studies and Environment Studies? What should be? MA करने के लिए क्वालिफाइंग, यूपीएससी के लिए क्या है क्वालिफाइंग एग्जाम? ग्रेजुएशन. सो MA के लिए क्या है क्वालिफाइंग एग्जाम? +2 के बाद तो MA नहीं कीजिएगा, ग्रेजुएशन तो करना पड़ेगा ना. अब इसमें भी थोड़ा टाइम लगा रहे हैं बोलने में, तो हाँ, वही मैं अब सीधा और भी नीचे जाऊंगा, एकदम बेसिक. हाँ, गेटिंग, somebody asked me, sir, what is NC, do we need to study NCERT also? I said कि NCERT तो काउंट भी नहीं होगा. You have to, अब जब खाना खाने जाते हैं, किसी ने बोला कि अच्छा खाना खा लिया, अच्छा यहीं रख दीजिए, यहीं नीचे रख दीजिए, खा लूंगा, प्लेट तो चाहिए ना भाई, दैट इज बेसिक्स. एनसीईआरटीज आर basic. You cannot even count them कि ये भी करे. It's like against the gravity I lifted this bottle, then opened this anti-clockwise, then brought this over, then I had a sip over my tongue which gloated into through my throat into my intestine. So ये यही चलेगा. NCERT is basic, okay, which उसको count भी नहीं होगा. And anybody who thinks that I have attended 2 classes today, for whom? I was saying the other batch, they were saying sir आज 2 क्लास थी. मतलब किसके लिए? कलेक्टर बनेंगे तो कोई दूसरा आके माहौल बनाएगा. हाँ. So it is, you have BA Honors English. Okay. So what is the qualifying exam for BA Honors English? Graduation. ठीक है. So for example, in this university, if you have done graduation from Delhi University, you will come under 85% quota. ठीक है. And if you, for example, a student A has done 12th not from Delhi, but he did his graduation from Delhi University, then he applied for these courses. He will, it is very likely to get selected or less likely? Very, very likely. Or a person who has done graduation from IIT Madras, he will not get selected. So 85% seats in Ambedkar University, Delhi, aud.ac.in is reserved for only those people who is graduated from Delhi. So what is the ground of, अब इसी से समझिए, what is the ground of discrimination? Place of birth. What is the ground? Place of education कोई place of residence. So it is understood कि since you have graduated from Delhi, it means you are an ordinary resident of Delhi. So Article 15 says no discrimination can be made on the grounds of religion, race, caste, sex, place of birth. खामोश है place of residence के नाम पर. It is silent. It means that there can be a discrimination on grounds of place of residence, and this is the reason why Ambedkar University Delhi is reserving 85% seats only for those students who have done their qualifying exam from Delhi. First example. Second example. UP government is distributing laptops to those who have done their 12th from Delhi, from UP. Can you get laptop? No, because you have, so what is the basis of discrimination? Place of residence. Article 15 says there will be no discrimination on grounds of religion, race, caste, sex, place of birth. It is silent on place of residence. Can there be a discrimination on grounds of place of residence? Yes. But in public employment, that is in Article 16, there can be no discrimination on grounds of religion, race, caste, sex, place of birth, place of descent, and place of residence. So no, Delhi Subordinate Selection Board, DSSB, cannot reserve a single seats for those who have done their qualifying exam from Delhi. Tamil Nadu Public Service Commission cannot, we'll come to it. इसका इतना आसान नहीं है, इसमें कुछ exceptions भी हैं, I'll come to that. So Parliament is having, so can you appear for West Bengal Public Service Commission? Can you appear for Kerala Public Service? Although they have recently started state PSC, otherwise they used to promote from what you call like Delhi DSSB. So although they have Danix, that comes through UPSC. That's a different story. So the point is, can you appear for Madhya Pradesh Public Service Commission? Yes. Can you appear for Karnataka Public Service Commission? Yes. Only thing is, they will put a qualifying exam. And some states make it a merit based. Like UP, Hindi is evaluated, counted in merit. So you are getting, so if they will make a qualifying paper or a language, state first language as merit based, then you have to pass that. Otherwise you can appear for all the exams, because there cannot be a discrimination in public employment on grounds of residence. And although I'll come to that, it will take 2 hours to discuss reservation. इतना आसान नहीं है. There are certain states which have passed, state legislative assemblies have passed certain legislation. Okay. So now broader understanding के लिए Article 15 शुरू करने से पहले, I'll come reservation Article 340. We'll discuss everything. But broader understanding के लिए, what all is covered under 15 and what is covered under 16? 16 covers only public employment and reservation in matters of promotion. If you are getting admission in IIT, it will be covered under 15 or 16? 15. If you are getting a DDA, Delhi Development Authority, flats announce करती है time to time. Those flats are very sought after. You first give you 50, you will give 50,000 rupees. After that, there will be a draw of lot. If your name comes, you will get flat at cheaper cost. Otherwise, the market price is very high. So it reserves seats for SC/ST in those flats. There is no seat reserved for any person in Delhi University of a state particular, because Delhi University is a central university. Certain colleges of Delhi University are financed by Delhi government. So Delhi government is getting strong now. If we are financing paying teachers, we should reserve seats for who have done their 12th from Delhi. So in Delhi University, there are 3 universities mentioned in the constitution: Delhi University, Banaras Hindu University, and Aligarh Muslim University at an institute of excellence. Otherwise, you only tell me that what is, if you are getting scholarship, it will be covered under 15 or 16. 15. If you are getting admission into a hostel, in our Delhi University hostel, although hostel is like, it is no less like IAS qualifying. Okay, out of 1,75,200 will get. So it's like very, very tough. It's very, very tough. So getting my point. In our hostel, there was like 206 seats, 11 seats for law. Okay, out of 20,000 people. Matlab, you feel like you are a king. Usme ek seat hasil karna was like very tough for me. Okay, thoda tarif apni kar do. So the point is, it's very tough because residential accommodation is not what you call that easy. Okay, it's very, very tough in Delhi University. Although there are some double seaters where you get, but seats are reserved not on the basis of residence in the hostel. Why? Why? Because it is a central university. But Ambedkar University Dwarka, when I graduated, after graduation, I applied for Ambedkar University Dwarka MA Development. Although I didn't took admission, but you apply for 50 courses. All the courses applied easily because 85%, my qualifying exam from Delhi University, so I came under 85%. Immediately I got, although I did not took admission, but I got admission in all the courses that I applied because 85% seats are reserved for Delhi University. But in South Asian University is established by an act, and then that it is a SARC university, 30 seats are there. For example, in a course, 15 seats are from India and 15 seats coming from, although it was more of a previous government's idea, so it's doing good, but it's not that, okay, multiple reasons are there. But yes, 50% seats are from India and 50% seats are from other SARC countries. Okay, all the other SARC, our neighbors. Okay, so so now the point is, ki in that, can there be I apply, I got there also, but the point is, can there be this thing ki usme, jo SARC university mein, can they reserve seats on the basis of place of residence? No, they cannot reserve. Why? Because it is not a state-based university and it is an intergovernmental sort of university established by Parliament, Finance, Ministry of External Affairs. Dhasu hostel dete hain, ekdam at a cheaper cost. But other than that, nothing is offered. So the point is, so you must understand that Article 15 deals with everything on earth other than public employment and promotion in reservation. There are certain other things also. Do you think that Article 15 is a general article or 16 is a general article? 15 is a general article, 16 specifically deals with public. Second thing, the founding mothers and fathers of Constitution were not fools, they were intelligent people. Why they added place of birth and descent in Article 16, but they deliberately did not add it in Article 15? Article 15 में कहा no discrimination on the basis of RRCSP, religion, race, caste, sex, place of birth. और आर्टिकल 16 में ऐड कर दिया नो डिस्क्रिमिनेशन ऑन द बेसिस ऑफ रिलीजन, रेस, कास्ट, सेक्स, प्लेस ऑफ बर्थ, प्लेस ऑफ डिसेंट एंड रेसिडेंस. व्हाई दे एडेड टू एडिशनल ग्राउंड्स इन 16? कॉमन सेंस है. क्यों ऐड किया? उनको मालूम है हर स्टेट अपनी सारी जॉब्स सिर्फ अपने लोगों के लिए रिजर्व कर देंगे. They knew that every state will try to attempt son of the soil and they will reserve public employment only for there. Now we will see reservation and what attempts have been made by Haryana reservation law, what attempts have been made by Rajasthan, what attempts have been made by Telangana, how the Supreme Court has responded, and whether it is a public employment or a private employment, we'll see this controversy. But without a shadow of doubt, in public employment, every time reservation is a conceptual thing. Every time the state legislature attempts to reserve the seat, many a time Supreme Court has declared them as null and void. Public employment में कोई discussion ही नहीं है. Private employment में there are certain things which is still debatable and UPSC will not ask a question. Actually they are gray. Actually they are gray because yet to be decided. But public employment में even Telangana, Rajasthan gave few percentage point to district wise or certain special. Telangana gave certain, उसको भी Supreme Court ने strike down because in public employment there can be no reservation on the basis of place of residence unless the parliament provides for it. We'll see that. So article 15 और 16 में सबसे पहले एक broad definition कि article 15 deals with everyone other than public employment and matters related to reservation, or 16 article 15 is applicable. Discrimination that is prohibited is religion, race, caste, sex, place of birth. यानी इसी वजह से इंडिया की सारी स्टेट गवर्नमेंट्स क्या कर रही हैं? They are providing certain things only to, for example, their scholarship, laptops, certain other things, for example, hostels, only to those people who are the residents of that state. That is why. So now we will see article 15 and principle of substantive equality. Okay. State job reservation do not contravene. Yes, of course it contravenes. 100 times Supreme Court says still the state attempts because there are political reasons. We will see reservation tomorrow. First we will see article 15. So it is article 15. So article 15 says the state shall not discriminate against any citizen on grounds of religion, race, caste, sex, place of birth, or any one of them. So it is consciously, conspicuously missing place of residence. So can there be a discrimination on grounds of place of residence? Yes. And why Ambedkar University Delhi is reserving 85% seats only for those people who have done their qualifying exam from Delhi, because it is permitted under article 15. Okay. Now we will see all the things. So this is a general article. This is a general article. No discrimination on the grounds of religion, race, caste, sex, place of birth. Okay. Next is no citizen shall be discriminated on grounds of religion, race, caste, sex, place of birth on access to, this is very, very general. Nothing to be understood. Access to shops, public restaurants, hotels, places of public entertainment, uses of wells, tanks, bathing ghats, roads and places of public resort maintained out of state funds. So now this is a very important thing. Two lines have been used. One, maintained out of state funds or dedicated to general public use. For example, there is a private tank, but the state is maintaining that, but the tank belongs to some great personality of village, but the state is maintaining from its own funds that tank. So it will also not discriminate because it is maintained out of state funds. Or I construct a tank or a bathing ghat or a road and I am dedicating it to general public use, but I am saying community X chhodkar. So I am dedicating to general public use, but I am discriminating on grounds of caste or religion or any other community. So actually it is violation of, so dedicated to general public use, it will also be covered. So article 15 का पहला तो एकदम general है. किसी भी मुद्दे में, किसी भी matter पर, any issue, there will be no discrimination on grounds of religion, race, caste, sex, place of birth. Next, no citizen shall be, what you call shall on the grounds of religion, race, caste, sex, place of birth, subject to any disability, liability or restriction with respect to access to bathing ghats and all, well tanks, maintained out of funds or this. Now next is, now article 15 clause 3. Nothing in this article shall prevent the state from making any special provision for women and children. Example? Huh? Delhi Metro, 33% reservation, approx 33% seats you will count is reserved for women. There is a bogie, special bogie for women. Okay, initially it was not there, somewhere around 2010 they started. So the point is कि special provision for women and children, this is permitted by the constitution. It will not be a discriminatory thing. Now इन तीनों चीजों में आपने क्या देखा? अब इसको और डीप समझते हैं. कहीं पे ऊपर कुछ, you have seen साइड में कुछ लगा हुआ है, कहीं पे वन या कुछ शगुफा, anything related to that, anything one या कहीं, no. So it means it is part of original constitution. It is part of ओरिजिनल कॉन्स्टिट्यूशन। अब आते हैं आर्टिकल 15 क्लॉज 4। नाउ व्हाट शी वाज सेइंग, nothing in this article or clause 2 of article 29, clause 2 of article 29, you cannot be what you call public institution mein you cannot be denied admission into an institution on grounds of religion, race, caste, sex nahi hai. Kyun? IP college for women, Miranda House, Lady Shri Ram college, so there is a special college for women, so they have deliberately not mentioned that in article 29. There can be a discrimination on grounds of sex, there can be a special college for women. Okay, so it says nothing in this article upar or in clause 2 where the public institutions, educational institutions, there can be no discrimination, okay, shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for SC/ST. Okay, so nothing can prevent for socially and educationally backward classes of citizens or for SC/ST. So what is the point out here? कि सबसे पहली बात कि रिजर्वेशन इन पब्लिक इंस्टीट्यूशन, एनीथिंग वाज नॉट देयर इन, इसके ऊपर ये क्या लगा हुआ है? 1, so it was added by, see नीचे, added by first Constitutional Amendment Act. So in public employment, अभी कुछ बेसिक जो बहुत ज्यादा कंफ्यूजन है उसको पहले दूर करते हैं. इन पब्लिक एम्प्लॉयमेंट देयर वाज अ प्रोविजन ऑफ रिजर्वेशन इन आर्टिकल 16 इन ओरिजिनल कॉन्स्टिट्यूशन, बट एनीथिंग अदर देन दैट, हायर एजुकेशनल, स्कॉलरशिप, एनीथिंग अदर देन दैट, देयर वाज नो प्रोविजन फॉर रिजर्वेशन. इट वाज एडेड बाय फर्स्ट कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट बिकॉज ऑफ चंपकम दोराई रंजन वर्सेस स्टेट ऑफ मद्रास. There was a case, Madras government through a general order provided reservation to certain communities in medical college. This was challenged by an aspirant into Supreme Court that this is violative on grounds of caste. Admission into a medical college will be covered under 15 or 16? 15. Employment in a assistant professor or dean of medical sciences would be covered under 16. So it was challenged in Supreme Court. Supreme Court said yes. There can be no reservation in public institution. It can be reservation in public employment, but not in public institution. So the parliament, Mr. Jawaharlal Nehru, first Constitutional Amendment Act in 1951, the state can make any special provision. The state can make any special provision for the advancement of socially and educationally. We came to Article 16. Okay. So the state can make any special provision for the advancement of socially and educationally backward classes of citizens or for the scheduled caste or scheduled tribe. So the provision, all these things, scholarship, housing complexes, DDMA seats are reserved for SC/ST communities or any other special provision was only after the enactment of first constitution. और एक और बात, there is a common WhatsApp university that reservation is only for 10 years. सुना होगा, जरूर सुना है ना कभी ना कभी की रीजन. यहां लिखा है 10 years? नो, 16 में भी नहीं लिखा है. इन मैटर्स ऑफ पब्लिक एम्प्लॉयमेंट एंड अदर मैटर देयर इज नो 10 year. Only in Article 334 of the Constitution, reservation for SC/ST in Lok Sabha and State Legislative Assembly was for 10 years, which is extended every 10 years. By 104th Constitutional Amendment, it was extended for another 10 years in the last year. So, there is no 10 year for public employment or colleges. 10 year was for Article 330 SC/ST reservation in Lok Sabha. Article 331 Anglo-Indian reservation in Lok Sabha up to 2 वो खत्म हो गया. Last year it ended. Now they won't be there. Article 332 SC/ST reservation in State Legislative Assembly वो है. Article 331 Anglo-Indian reservation in State Legislative Assembly वो खत्म हो गया. And Article 334 says it is for 10 years. जिसको every 10 year you extend it by another 10 years. So 10-year provision is related to seats in Lok Sabha and State Legislative Assemblies. It is nothing to do with public employment as per the University of WhatsApp. Okay, so this is Article 14. This was added by which Constitution Amendment? First. Yani all these provisions have come by first Constitutional Amendment. Next is, अब नीचे भी कुछ लिखा है 2 लिखा है ना जी. एक तो ये Constitution अपडेटेड नहीं है, ये तो सबसे चैलेंजिंग बात है, चलिए वो तो मुझे रटा हो। तो सुनिए, ये मैं बताता हूं, सुनिए, नथिंग इन दिस आर्टिकल और सब क्लॉज ऑफ जी। अब सुनिए, सब क्लॉज ऑफ जी ऑफ क्लॉज 1 ऑफ आर्टिकल 19, क्लॉज 1 ऑफ आर्टिकल 19 इज राइट टू क्लॉज 1 जी, ठीक है, राइट टू आर्टिकल 19 1A फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, बी right to assemble peacefully without arms, C right to form association, union or cooperative, D right to travel throughout the country, E right to reside and settle, F has been deleted, G right to practice any trade, occupation and profession. So ये क्या कह रहा है, nothing in this article, यानी article, which article, 16 और 15, 15 की बात हो रही है ना, 16 तो इसके नीचे है, ठीक है, नथिंग इन दिस आर्टिकल और इन सब क्लॉज जी ऑफ क्लॉज 1 ऑफ आर्टिकल 19, यानी राइट टू प्रैक्टिस एनी ट्रेड, ऑक्यूपेशन एंड प्रोफेशन, शैल प्रिवेंट द स्टेट फ्रॉम मेकिंग एनी स्पेशल प्रोविजन बाय लॉ। अब कह रहा है, उसमें क्या कह रहा था, अब यू सी द लैंग्वेज ऑफ द कॉन्स्टिट्यूशन, ये यूपीएससी प्रीलिम्स में पूछेगी। यहां कह रहा है नथिंग इन दिस आर्टिकल शैल प्रिवेंट द स्टेट फ्रॉम मेकिंग एनी स्पेशल प्रोविजन, यानी दिस कैन बी डन बाय एन एग्जीक्यूटिव ऑर्डर। ये स्पेशल प्रोविजन तो लॉ भी हो सकता है, एग्जीक्यूटिव ऑर्डर भी हो सकता है, नोटिफिकेशन भी हो सकता है, कुछ भी, इट कैन बी एनीथिंग। बट इन द सेकेंड आर्टिकल 15 क्लॉज 5 इट सेज नथिंग इन बाय लॉ, यानी अगर ये करना है तो स्टेट को एक लॉ पास करना पड़ेगा। सो नथिंग इन दिस आर्टिकल और इन सब क्लॉज जी ऑफ क्लॉज 1 ऑफ आर्टिकल 19 शैल प्रिवेंट द स्टेट फ्रॉम मेकिंग एनी स्पेशल प्रोविजन बाय लॉ। किनके लिए स्पेशल प्रोविजन? For the advancement of socially and educationally backward classes of citizens, OBCs. Socially and educationally backward classes of citizens and SC, STs. We will see who is an SC. This is given in Article 341. Who is an ST? This is given in Article 342. Who is an OBC? This is given in Article 342A. अभी समझेंगे, आएगा वक्त तो समझेंगे। Okay, so it is socially and educationally backward classes of citizens or SC, ST. Insofar special provisions relate to their admission to educational institutions including private educational institutions, यानी this, इसके आगे क्या लिखा है ये 2, तो नीचे देखिए 93rd कॉन्स्टिट्यूशनल अमेंडमेंट इंसर्टेड बाय 93rd कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 2005। ओके, आर्टिकल 15 का जो पहले था इट वाज अ जनरल क्लॉज, स्टेट कैन मेक एनी स्पेशल प्रोविजन फॉर विमेन एंड चिल्ड्रन, और बाद में सोशली एजुकेशनली बैकवर्ड क्लासेस और एससी एसटी, एक जनरल स्कॉलरशिप दीजिए, कुछ भी दीजिए। यहां दे हैव प्रोवाइडेड इट अ वेरी वेरी स्पेशल थिंग, इट सेज नथिंग इन दिस वाज एडेड इन द ईयर 2005, nothing shall prevent the state from making any law for the advancement of socially and educationally backward classes of citizens or SC ST, admission to educational institutions including private institution, यानी जिंदल यूनिवर्सिटी, अशोका यूनिवर्सिटी, एमिटी यूनिवर्सिटी, वेदर एडेड और अनएडेड, अगर 1 रुपया भी गवर्नमेंट नहीं दे रही है, इवन गवर्नमेंट इज नॉट गिविंग अ सिंगल रुपी, देन ऑल्सो गवर्नमेंट कैन प्रोवाइड बाय लॉ रिजर्वेशन फॉर ओबीसी एंड एससी एसटी इन दोज private educational institutions. See, educational institutions whether aided or unaided by the state other than minority educational institution referred to in clause 1 of article 30. Why minority institutions are exempted from OBC and SC ST reservation? Suniye. Okay. No Muslim or Christian can be SC. The presidential order issued against under article 341, as per now the Muslims and Christians cannot be SC because untouchability is the basis, and in these religions Supreme Court on 16 November 1992 says that these religions do not promote untouchability, so they cannot be SC. Now if you give 15% reservation to SC community and STs are there, Ladakh and Jammu region and some, and 7.5 to ST, so what is the purpose of that religious minority institution? Purpose is to reserve 50% seats for not minorities, religious minorities. Minorities can be linguistic also, but religious minorities. Sirf religious. Now if you reserve seat 50% plus 15% plus 7.5% and 27%, so what will be unreserved? Huh? 1%? EWS आ गया तो 108%. So the point is कि so a 93rd constitutional amendment act provided कि educational institution में OBC और SC ST के लिए reservation होगा, चाहे वो private हो, aided हो, unaided हो, except माइनॉरिटी एजुकेशनल इंस्टीट्यूशन छोड़कर बाकी सब पर हायर एजुकेशन में देयर विल बी रिजर्वेशन. दिस वाज प्रोवाइडेड बाय 93rd Constitutional Amendment Act. So Article 15 we have dissected. First is the general provision: religion, race, caste, sex, place of birth. Second, access to hotels, restaurant, bathing ghat, either aided, unaided, maintained out of state funds. Then a special provision for women and children. Fourth, by any special provision for socially educationally backward classes and SC ST by the state, scholarship या कुछ भी. Fifth, higher educational institution में SC ST or OBCs, so you basically see here SC ST and other backward socially and educationally backward classes को reservation देंगे. Is it in private colleges? Yes, if the state provides by law. Is it in unaided colleges? Yes, aided or except minority. अब इसमें एक और ऐड हो गया आर्टिकल 15 क्लॉज 5 के बाद आर्टिकल So we have 103rd Constitutional Amendment Act. Okay. अभी इसे पता है कि सारे बच्चे देख रहे हैं तो जल्दी नहीं खुलेगा. Okay. So this is 103rd Constitutional Amendment Act. It came in the year 2019, 8 January. Minister for Social Justice and Empowerment, Thawar Chand Gehlot ji presented the bill and it got the presidential assent on 12th January 2019. Now this says, अब सुनिए, आर्टिकल 15 में क्लॉज 6 जोड़ दिया. इट एडेड, अभी तक हमने क्या देखा था, आर्टिकल 15 क्लॉज 5. अब उसमें 5 के बाद अभी तक तो 6 आता है, सो उन्होंने 6 जोड़ा. ओके, आफ्टर 5 इट इज 5, आफ्टर 5 इट इज 6. ओके, सो इट एडेड इन आर्टिकल 15 ऑफ द कॉन्स्टिट्यूशन आफ्टर क्लॉज 5 द फॉलोइंग क्लॉज शैल बी इंसर्टेड, नेमली. सो दिस विल बी क्लॉज 9, 6. ओके, वेरी गुड. सो nothing in this article, yani which article, 15 or 16, 15, nothing in this article or sub clause G of clause 1, that is article 29, no discrimination on the ground of religion, race, caste in public institution. But if you are providing reservation to EWS, you are actually discriminating. So usko clause ko exempt kar raha hai. You are getting my point na? So nothing in this article or clause G of clause 1 and article 19 or clause 2 of article 29, ये तो right to practice any trade, occupation, profession, anything, क्योंकि article 15 is general. Article 15 is a general article. It says any special provision for the advancement of economically weaker section other than the classes mentioned in clause 4 and clause 5. अब EWS को how they could have defined? It would have been beyond impossible कि EWS जनरल अनरिजर्व्ड कितना कॉम्प्लीट. उन्होंने कहा अदर देन दोज हु आर इन क्लॉज 4 and 5. सो जिसको रिजर्वेशन मिल रहा है उसको छोड़कर, तो कौन आ गया, अनरिजर्व्ड. तो हाउ दे कुड हैव रिटन की नॉन क्रीमी, क्रीमी, पूरा. यू आर गेटिंग माई पॉइंट. इट वुड बी वेरी, सो दे थॉट की इजिएस्ट वे इज अदर देन दोज हु आर गेटिंग रिजर्वेशन इन क्लॉज 4 and clause 5, यानी ओबीसी एंड SC ST को छोड़कर बाकी सारे. So, state can make any special provision for the advancement of economically weaker section of citizens other than those mentioned in clause 4 and clause 5. यानी उनको स्कॉलरशिप या कुछ भी स्टेट दे सकता है. आगे वो भी तो IIT जाएंगे. नाउ यू हैव, और उसके बाद सब मिलके TCS. ओके, ठीक है. उसके बाद any special provision for the advancement of economically weaker section other than those in clause 4 and clause 5. ये ज्यादा ही लग रहा है कि ये अब दिख रहा है, दृष्टिगोचर है, ठीक है. सो फॉर स्पेशल प्रोविजन रिलेटेड टू एडमिशन टू एजुकेशनल इंस्टीट्यूशन, यानी आर्टिकल 15 क्लॉज 5 वाज ओबीसी SC ST इन IIT. आर्टिकल 15 क्लॉज 5 था ना, एजुकेशनल इंस्टीट्यूशन. ये किसको दे रहा है, इकोनॉमिकली वीकर सेक्शन. एडमिशन टू एजुकेशनल इंस्टीट्यूशन इंक्लूडिंग प्राइवेट एजुकेशनल इंस्टीट्यूशन, अमेठी, अशोका एंड जिंदल, वेदर एडेड और अनएडेड, यानी aided or unaided, other than फिर वही minority, because 10% this SC ST OBC, फिर minority education institution. You are getting St. Stephen's College versus University of Delhi, 50% seats can be reserved for religious minorities. Indira Sahni case को ही reaffirm. So St. Stephen's reserve 50% seat for religious minorities, and Jamia Millia Islamia reserve 50% seats for religious minorities. And what about AMU? Aligarh Muslim University? Huh? Not a single seat is reserved for any Muslim in Aligarh Muslim University. It is not a minority institution. Allahabad High Court ka judgment hai, not a single seat till date has been reserved for any Muslim. Only seats are reserved for those who have done their qualifying exam from AMU. So if you are applying for medicals, if you have done your +2 from AMU, you will be coming under reservation. Not a single seat is reserved for Muslim in Aligarh Muslim University. It is not a minority institution. You go and see the prospectus, koi bhi seat Muslims ke liye reserve nahi hai. It is not. But Jamia, 2009 National Commission for Minority Education Institution Act has reserved 50% seats for Muslims after giving minority tag to Jamia, and the same has also been challenged in Supreme Court, which is pending. But Supreme Court in St. Stephen's College versus University of Delhi case mein kaha, St. Stephen College can reserve 50% seats for Christians, and that they are doing. Okay, so that is. But in AMU, there is not a single seat that is reserved for any Muslim. Only if you have done their qualifying exam, seats are reserved. So normally in what you call schools, if you are gone, so you have an edge in AMU का medical entrance से जितना tough होता है, उतना ही tough +2 का भी होता है. Why? Because if you get in +2, you are getting my, then you are 1 lakh students are sitting for 100 seats, 700 students are sitting for 100 seats, and out of those 700 also, or 2000, 1500 will go to social sciences, huh? 300 has that IIT, then going to TCS later. So 300 so bacha, wahi 400-500 biology, and they will compete for 100 seats in Jawaharlal Nehru Medical College, that is in AMU. So that is, anyways. So you, whether aided or unaided, other than minority institution in clause 1 of Article 30, with, in case of reservation in addition to existing seats, subject to a maximum of 10%. पहली बात, UPSC का पहला लाइन, Article 15 reserves 10% seats for EWS. No, up to maximum 10%. जैसे it says, the state shall reserve not less than 33% seats for women in panchayat. So Bihar has made it 50%, क्योंकि Constitution कह रहा है not less than 33%. You have to be very alert in examination hall. Prelims में क्या statement वो? It is saying not. यहाँ it is not subject to a maximum of 10%. So can EWS have a reservation of 2%? Yes, because the maximum that is given, or it will be done by a law or by an executive order. क्योंकि यहाँ क्या लिखा है? Special provision. So it will be done by an executive order. Next, it automatically done, or after coming a special notification has to be issued. कोई फंडामेंटल राइट नहीं है. रिजर्वेशन इज नॉट अ राइट. ये एक प्रोविजन डाला है, स्टेट चाहे तो करे चाहे तो ना करे. सो आफ्टर आर्टिकल 15(6) हैज बीन एडेड, a special notification has been issued by central government reserving 10% seats for economically weaker section. The state which wants to give in state institution, they have to come with their own notification. If they want to give, they will actually give. So you see, it says any special provision, any special, kahin bhi by law nahi hai. Okay, so you are getting. For OBC reservation in higher educational institution, Article 15 Clause 5, you need a Central Educational Institution Act to reserve 25% seats in IIT, Delhi University, JNU for other backward classes. Okay, you are getting my point. Now you have, अब नीचे कह रहा है कि EWS है कौन भाई? अभी कहा कि 10 लाख, 5 लाख, 8 लाख, 2 लाख, 1 रुपया, कुछ तो नहीं कहा. अभी नीचे कह रहा है कि भाई इसमें तो थोड़ा ये है. So they have added, for the purpose of this article and Article 16, economically weaker section shall be notified by the state from time to time on the basis of family income and under indicators of economic disadvantage. So किस पर छोड़ दिया? सबका मालिक एक है, स्टेट पर छोड़ दिया. State will determine time to time who is an economically weaker section. Okay, so if you got this na. So Article 15 is dealing with what all things? सबसे पहले 15 clause 1 is a general कि state, religion, race, caste, sex और place of birth के basis पे discrimination नहीं करेगा. Residence के basis पे कर सकता है. ये कहा है कि कीजिए, पर मना भी. जैसे कि you are getting my, जैसे during summer holidays, your parents say कि okay you enjoy, then you didn't study for 48 days. So then you only said at the onset कि you enjoyed, but it was an implied कि थोड़ा थोड़ा
देख लेना. Okay, so the point out here is कि this is like Article 15. Second, it says a very general statement that it should be. ये तो 15 देख लिया आपने economically. Then we will write also. Don't worry. It is more important to understand. Everything which I have discussed is written in a printed format Times New Roman 12 in the booklet that is given to you. And there is enough of literature that is given to you to qualify UPSC along with your mohalla. Okay, enough of literature. इतना नोट्स है आपके पास कि 4 बार यूपीएससी क्वालिफाई होगा, हर बार फर्स्ट रैंक आएगा. ठीक है, इसीलिए वो डू नॉट इंक्रीज योर अननेसेसरी बर्डन. व्हाट इज गिवन टू यू, यू फर्स्ट कंप्लीट दैट. ओके, मोर देन एनफ मटेरियल है. खुशी होती है नई किताब खरीद के. आई नो अ फ्रेंड ऑफ माइन, ही अपलोड्स अ बुक एवरी डे ऑन व्हाट्सएप. सो आई आस्क्ड हिम, actually he is into services. I said कि भाई तू खत्म करता है कि हर दिन कैसे पॉसिबल होगा? It is absolutely impossible. There are few people whom I know that they cover also, but there are some who upload. So किताब खरीदने से अगर ज्ञान होता तो जो बुक वाला है वही आइंस्टाइन बन जाता, दिन भर पढ़ता ही रहता उठाकर, शौक से होता है. Okay, so you have what you call, you see this Article 15. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth or any of them. This is a general provision. Next you have no citizen. अब ये सब अपना public restaurant, bathing घाट, इसमें conceptual point है बस कि maintained out of state funds or dedicated to general public use. Article 15 clause 3 is the state can make any special provision for women and children. Article 15 clause 4 was added after Champakam to Rai Ranjan judgment, and by which constitutional amendment? First Constitutional Amendment Act कि state can make special provision for the advancement of socially and educationally backward classes of citizens and SC, ST. अभी 93rd Constitutional Amendment Act के जरिए 2005 में educational institution for SC, ST and OBC this reservation has been provided, and this अच्छा इसके Article 15 में automatically provided or state has to bring a law? Yes, because it says by law. So state center has passed Central Educational Institutions Act. So reservation 27% for OBCs, 15 for SC and 7.5 for ST in educational institution other than minority, private, aided, unaided, other than minority. And finally Article 15 clause 5 के बाद जिनको नहीं मिला था 16 में उनको भी दे दिया कि up to 10%, but that by law or by a special provision. Special provision एक नॉट अच्छा. वन थिंग, व्हाट इज द डेफिनेशन ऑफ स्टेट इन आर्टिकल 12? स्टेट, हर जगह स्टेट आ रहा है ना, स्टेट. सो इट इंक्लूड्स द स्टेट गवर्नमेंट और नॉट? यस. सेकेंड, डज द ये लिख देने से रिजर्वेशन मिल गया? नो, दिस इज जस्ट एन प्रोविजन, इनेबलिंग प्रोविजन. दिस इज जस्ट अ प्रोविजन. स्टेट कहीं भी शैल लिखा है, स्टेट में. सुप्रीम कोर्ट सेज एवरी मॉर्निंग रिजर्वेशन इज नॉट अ फंडामेंटल राइट. Reservation is not a fundamental right. It is not a fundamental right. This is just a provision in the constitution which the state may or may not use. First thing. Second thing, if the economically weaker section 10% reservation is given, अभी state government की jobs भी आती हैं. सुना होगा आपने state PSC, which nowadays state PSCs are reforming. So and the what you call the people who are coming are also way better. Previously, they used to ask questions like this scheme was launched at 11:30, 31, 32. Tough factual question. Now they are asking quite sensible questions. So, state PSC में ये लागू होगा. This is a provision in the constitution. Whichever state wants, it will pass a notification. Whichever state wants to reserve 27% seat for OBC in education, it has to pass a law by state legislature. Whichever state wants. So after 103rd constitutional amendment was passed, all the states in India passed the notification to provide 10% EWS in their state universities and colleges and public service commissions. क्या ये state पे अपने से लागू हो गया? No. So can the state take away? Nanosecond में. It is only a कहीं भी shall बोल रहा है. Anyway, it is just a provision. Can reservation be taken away in nanoseconds? It is, although there are political ramifications and also the principle of equity and justice, it will not be done away with. And that is, whenever you write about a reservation, you will have a positive approach. whatever thing, this is a very sensitive approach. It's a very sensitive topic. I know how students have reacted at times, but we are here for a scientific empirical examination. Whatever they ask, we have our own radio, a very balanced, nuanced and a very fine answer. That of course the principle of equity, and it must be better targeted affirmative action in support of reservation, whichever community you belong to. It's a very sentimental, and human beings are bound to be sentimental. Do you see some people, they fight Mohan Bagan? Huh? They fight for Mohan Bagan. Okay, so like, don't be sentimental. Okay, chill. Kya dikkat hai? So if they ask you, I know there was somebody who actually whenever there was a topic discussed, he sat like this. And he was writing mains, so people asked that you also want to come. He got 17 rank. So actually he made it a point कि free में बिल्कुल नहीं बांटना है. Getting my point? And there are few, I go around, I see कि बात कर रहे होते एकदम ट्रीटी ऑफ वेस्टफीलिया, लाइक अभी एक पीएचडी यहां से निकलेगी. ओके, सो गेटिंग हायर, डू नॉट गो इनटू हायर डोमेन, बेसिक्स मस्ट बी डन फर्स्ट. सो आर्टिकल, नाउ मोस्ट इंपॉर्टेंट थिंग, इज रिजर्वेशन अ फंडामेंटल राइट? नो, इट इज अ प्रोविजन you may, or but of course it is a necessity. Till now we are dealing with reservation in public employment, or we are dealing in other matters. अभी तो अदर मैटर, अभी तो कल whenever we meet for next time तब शुरू होगा करामत. That would be reservation in. So first we will do Article 340 of the Constitution, National Commission, what you call Special Commission for time to time for backward classes commission. Then we will do public employment, उसमें वक्फ बोर्ड, what are the various, अभी तो बस public institutions में है. So we have done the, dictate नहीं कराए, हाँ हाँ, so dictate कराए ना, हाँ. Okay. Huh? Let me go by the intuition. Please write. Article 15. Okay. So Article 15, please write. Article 15. Article 15, okay, please write. Article 15 prohibits discrimination. Article 15 prohibits discrimination on grounds only of religion, race, caste, sex, place of birth. On grounds only of religion, race, caste, sex, place of birth, or any of them. ब्रैकेट में लिख दीजिए आर्टिकल 15 क्लॉज 1. Then you write Article 15 clause 2 prohibits discrimination in access to. Article 15 clause 2 prohibits discrimination in access to just few you write, public restaurants, bathing ghats, prohibits discrimination in access to public restaurants, bathing ghats, roads, etc. Maintained wholly out of state funds or dedicated to the use of general public. This is very important. Maintained wholly out of state funds. Wholly or partly भी ब्रैकेट में लिख दीजिए. Maintained wholly or partly out of state funds or dedicated to the use of general public. Okay. Next you write
The state is permitted to make special provision for women and children. Positive लिखिए इसका. The state is permitted to make. The state is permitted to make special provision for women and children. The state is permitted to make special provision for women and children. Next you write bracket, इसमें भी लिख दीजिए article 15 clause 3 लिखिए 15 clause 3. The state is permitted to make special provision for women and children. Next you write, next line, post Champakam Durai Ranjan judgment, post Champakam Durai Ranjan judgment, post Champakam, Champakam, okay, Champakam, you write together, Durai Ranjan, D-O-R-A-I, D-O-R-A-I, Ranjan, Justice Ranjan Gogoi, Ranjan. So post Champakam Durai Ranjan judgment and also the understanding of the parliament and also the understanding of the parliament. Article 15 clause 4, Article 15 clause 4, you write Article 15 clause 4 was added through First Constitutional Amendment Act. Article 15 clause 4 was added through First Constitutional Amendment Act. First Constitutional Amendment Act. Then you write आगे, this permits the state to make special provision. This permits the state to make special provision This permits the state to make special provision for the advancement of socially and educationally backward classes of citizens. This permits the state to make special provision. This permits the state to make special provision for the advancement of socially or educationally backward classes of citizens. This permits the state to make special provisions for the advancement of socially and educationally backward classes of citizens and SC/ST. Okay? Next you write the 93rd Constitutional Amendment Act The 93rd Constitutional Amendment Act 2005 93rd Constitutional Amendment Act 2005 empowered the state to make special provision empowered the state to make special provision 93rd Constitutional Amendment Act empowered the state to make special provision for socially and educationally backward classes of citizens. Empowered the state to make special provision for socially and educationally backward classes of citizens or SC/ST, socially and educationally backward classes of citizens, or SC/ST, with respect to socially and educationally backward classes of citizens, or SC/ST with respect to admission in educational institutions, with respect to admission in educational institutions, with respect to admission in educational institutions, whether
aided or unaided, with respect to admission in educational institutions, whether aided or unaided, including private, whether aided or unaided, including private, except minority educational institutions. ओके ठीक है. अब ये लिखा है स्टेट कैन प्रोवाइड रिजर्वेशन फॉर ओबीसीज एंड एससी एसटी इन हायर एजुकेशनल इंस्टीट्यूशन. स्टेट मस्ट हैव पास्ड अ लॉ, must have passed a law. So you write, to implement this provision, central educational institution, to implement this provision, central educational institution, bracket में reservation in admission, close the bracket, to implement this provision, central educational institution, bracket में reservation in admission, close the bracket, to implement this provision, central educational institution, bracket में reservation in admission, close the bracket, Act 2006 was passed. Act 2006 was passed. Okay, full stop. आगे लिखिए. Now what we have to see? You see Article 15 Clause 6. Then you write 103rd Constitutional Amendment Act of 2019. 103rd Constitutional Amendment Act of 2019 provided for maximum up to 10%, maximum up to 10%, maximum up to 10% reservation, maximum up to 10% reservation in educational institution, whether aided or unaided, in educational institution, whether aided or unaided, comma, including private, whether aided or unaided, including private, comma, except minority educational institutions, except minority educational institutions, up to 10% लिख दिया ना, for those other than the classes mentioned in clause 4 and clause 5, other than the classes mentioned in clause 4 and clause, for those other than the classes mentioned in clause 4 and clause 5, other than those classes mentioned in clause 4 and clause 5, bracket में लिखे SC, ST, OBCs, close the bracket, SC, ST, OBCs को छोड़ के, other than those in clause 4 and clause 5, मतलब SC, ST, OBCs को छोड़ के, full stop. नीचे लाइन चेंज कीजिए, लिखे इकोनॉमिकली वीकर सेक्शन शैल बी डिटरमाइंड बाय द स्टेट फ्रॉम टाइम टू टाइम. इकोनॉमिकली वीकर सेक्शन शैल बी डिटरमाइंड फ्रॉम बाय द स्टेट फ्रॉम टाइम टू टाइम. ओके, शैल बी डिटरमाइंड बाय द स्टेट फ्रॉम टाइम टू टाइम. ओके, क्या है यही, ठीक है. सो दिस इज डन. नेक्स्ट पूरी क्लास आर्टिकल 16 पे भी हो सकती है. क्यों? क्योंकि वी विल डू सेकंड बैकवर्ड क्लासेस कमीशन, पब्लिक रिजर्वेशन, रिजर्वेशन इन एम्प्लॉयमेंट, रिजर्वेशन इन प्रमोशन, कॉन्सिक्वेंशियल सीनियोरिटी, सारी चीज करेंगे. ओके,
So we'll continue with 16, 17 and happy Independence Day. Take care. Take care. Independent in evening. Okay, thank you. Take care.